May I please, Your Lord?
Yes,
My Lord, for motion tomorrow, my Lord.
tomorrow not possible. You take a date from him after vacation. Not possible.
My Lord, AB, my Lord.
Maybe tomorrow not possible. We have already 50 meters fixed tomorrow.
My Lord, then, my Lord, 18, my Lord.
18. 18.
That regular verification, my lord.
Not
Ye-
tomorrow. Not tomorrow. After vacation.
My lord, item number 20. Can you
Kobe,
pass
Kobe.
on for detail? 21.
Yes,
Item number 21. Can you pass over for detail, my lord?
21.
Yes, my lord. You picked on 18, my lord, kindly.
18.
Yes, my lord.
Yes, CD available.
LCR, my lord. LCR received, my lord.
LCR received. On the pair being made by Mr.
Yes, you are, my
S.C. Omen, Learned Counsel for the accused, list the matter on
19, my lord. 19.
19.
sir. 18. sir.
18.
Yes, my lord.
Okay.
Okay.
Yes,
Yes, Lordship.
yes.
I beg to mention for listing for withdrawal of a bail application for
Wait.
tomorrow, Lordship.
Tomorrow. Okay.
August, Lordship.
May I please, your lordship? With the consent of other side, I beg to mention for item number 50.
50.
50.
My lord, I appear for the respondent here. I was the complainant. They are up against concurrent finding. They are seeking an accommodation today. All right. My lord will give me a fixed date on 23rd of January. It's a hearing matter. They are up against.
Item number 50.
50.
50.
Yes, as agreed by learned advocates of both the parties, list the matter on
23rd. 23rd of
23rd. Yes.
Yes.
Okay.
January.
May I please, your lordship? For listing, your lordship. For listing AB, your lordship. Tomorrow.
When?
Tomorrow, your lordship.
No.
Then after vacation.
Yes, you take a date from him.
My lord, this matter may be listed on 18th, my lord.
18th. Yes.
This matter may be listed on 18 lots. 18 of
Okay.
them.
Okay.
May I please, your lordship? Criminal petition number 977 of 2022. Matter may be listed after vacation.
Item number
For listing.
listing on.
After vacation.
Okay.
24.
Item number 30, my lord.
30.
30, my lord. Perhaps CD is not received, my lord. CD not received. The petitioner is in April, my lord.
He is on interim.
Yes.
Yes. On the pair
Well,
with matter,
here-
Mr. S. Islam,
Yes.
learned
My lord,
counsel
charge
for
sheet
the
submitted, my
applicant.
lord. I have received information on charge sheet submitted, my lord. Here it is.
That's it. What is the number?
80/23 dated 31/10/23, my lord.
Under section?
That is not here, my lord. Only information is here, my lord.
31.
10.
Whether search it is a file against the present applicant or not. That is also not
No,
available. with
only
it.
information.
Okay, you confirm it
My lord, my lord.
at
I
2
will
p.m.
At 2.
At 2 p.m.
I will
If
confirm.
possible, we will dispose of it today.
My lord.
Yes.
I need to mention 35 lordship.
Item
35 lordship. Maybe a consult.
yes.
35, my lord.
CD available.
No, my lord. 35 CD not available.
35 CD not available. On the pair being made by Mr. P. Talley, learned counsel for the applicant. List the matter on COVID. 24.
Interim here.
Till then, interim order shall continue. On that day, learned additional PP shall produce the case diary before the court.
Lordship, I beg to mention for listing of an IA criminal 397/2024 for
Wait.
tomorrow. Correction, Lordship, there's a small correction
What
in the
correction?
order. Like the date of the year of the case number is wrong. It was a typographical mistake from the council's part.
In bail application.
A criminal petition.
When the order was passed?
on 22nd of December, 2023.
After vacation, not tomorrow.
On
Another is another listing for AB 455 of the 2024
Take a date from him.
After vacation,
after vacation,
yes, on 22nd January.
both 22nd obliged.
Similar plat, Lordship. Similar plat.
Take a date from him.
24 January. 24 January.
Please, your lordship.
Ah,
But I am paying for withdrawal, my lord, tomorrow, my lord.
okay.
And another, my lord, for extension of interim order.
When?
Interim orders there, my lord, it may be extended, so will be taken tomorrow, my lord.
No, not tomorrow.
22nd January.
This matter was fixed on fifth, but without, in my absence, actually, somebody took time. And now I want to make a prayer for fixing it on 22nd. And this is
Take a date
776.
from him.
Okay, on 22nd.
Obliged.
Item for withdrawal. Item number 52.
You want to withdraw this matter?
Yes,
What is your name?
P90 on behalf of
P.
P90.
Ms. So-and-so, learned counsel appearing on behalf of Mr. D. Mehdi, learned counsel for the applicant, submits that she has the instruction to withdraw this application. Pair is accordingly allowed. This BA instance dispose of on withdrawal.
For motion bail application, item number 1.
Yes.
My lord, allegation under 21B, Lordship. My lord, 46 days as on today, we are in custody, Lordship. My lord, the bail was taken on 2012, Lordship. On that the CD was called, but my lord, may kindly see the order on 2012.
No
CD
CD was called
No
for.
city was.
Yes, Lordship, that is the order, but on that day, CD was called, Lordship. I moved the.
Okay, from which PS?
Bongaigaon,
my lord.
Bongaigaon. Okay, CD on 19th,
My 19th, my lord.
19th.
Item number 2.
It will show lordship, number for 39 application, today, my lord, 27 days. My lord, after is page 8, my lord. Translation copy.
Whether the victim card was recovered?
My lord, recovered on that page.
When?
My lord, on that day itself, my lord, recovered, when the information, got information, my lord, thereafter he recovered, and she is staying with parents, my lord.
CD and the
Right.
statement of the victim
160.
card under section 164 CPC on when? 20?
My lord.
22nd.
22nd.
22nd?
Right.
Okay.
Item 3.
My lord, the petitioner was arrested, my lord, on 30/12/2023, my lord.
30?
On 30, my lord, 30 December, my lord. Page 10, my lord.
30
FIR,
of
December, my lord, 2023. Page 10, my lord, FIR. With due respect, I would like to inform that yesterday on about 10:30, while I was on duty, an unknown person, but later came to know that his name is Paikus Biazurika Ramti, so suddenly entered my room with some random person and threw the file on my table, introducing himself as a politician. As my duty, I was authorized everything which was necessary for the treatment of the patient in accordance with the rule. Later, we found that the patient party that day which he brought with him does not know him at all. And then he started verbally abusing the other staff member and forcefully asking my seal and without my knowledge. I asked him to leave many times, but he was not listening, loitering again and again. After that, I find him behavior suspectful in many ways and informing him, and he concealed his identity.
where is the vernacular?
My lord,
No, not vernacular.
English type matter. My lord, the unfortunate incident take place on 30 to
28, my lord. One of my friend was injured due to accident, my lord. I took him to the, along with him, my lord, medical college. There is some herbal, my lord, exchange of word with the doctor, my lord. With the doctor for early treatment, I am pressing, my lord. That was the doctor ignored with the petitioner, my lord. And due to fear, my friend also after day after reluctant to recognize me for not getting treatment, my lord. They are searched 4 sections, my lord. 2 sections already available, my lord. Here is 420. 420, no ingredients in my case, my lord.
Yes, Mr.
My lord,
Verma?
my lord, 18th, my lord.
Why?
CD, my lord.
CD. Is it
CD.
necessary to peruse the CD here?
My lord, here,
Huh?
12 days, he is helping my one of patient, my lord. Only.
but not identified by the patient also, my lord.
Mhm.
Well, look, due to fear, my lord, not getting the
How he
treatment,
entered the room, my lord. Doctor's
he
room.
suffer a lot, my lord.
What is your name?
My lord, Bhagyajyoti
Calculate
Hazarika,
Your name?
my lord.
Heard, Mr.
Yes, we can.
S. Soikia, learned counsel for the accused, and also heard Mr. B. Sharma, learned additional PP for the state respondent. This application under section 413(9) CRPC is preferred by accused Bhagyajyoti Hazarika Rongpi on Bhagyajyoti Hazarika Rongpi, who has been languishing in jail Hazot in connection with Bhangagar PS case number 334 of 2023 under section 353, 419, 420, 294 IPC for grant of bail. Is to be noted here that above noted case has been registered on the basis of an FIR lodged by one Dr. Perona Das on 29/12/2023. The essence of allegation made in the FIR dated so and so is that on the night of 28/12/2023 at about 10:30 p.m. one person, namely Bhagyajyoti Hazarika Rongpi, personating himself as politician, entered into her room and started misbehaving with her. The learned counsel for the accused submits that the accused was arrested on 30/12/2023 and since then he has been languishing in jail Hazot. Further, Mr. Soikia, learned counsel for the accused submits that section 294, 419 are available, and though section 420 IPC is also added, yet the no ingredients of the said offenses appears to be made out from a bare perusal of the FIR, and that he has been languishing in jail Hazot for last
12 days.
12 days, and therefore it is contended to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP, submits that at this case there may be called for. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record. And it appears that he was arrested on 30/12/2023. And since then, he is behind the bar for last 12 days. Further, it appears that the offense, the case was registered under section 353, 419, 420, 294 IPC. Out of the aforesaid offenses, the offense under section 419 and 294 are available. And though no ingredients of the offense under section 420 IPC appears to be made out from a perusal of the FIR. In view of above, and also in view of the period of detention and the nature and gravity of the offense, his further custodial detention seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000, with one security like amount to the satisfaction of the CJM Kamrupen, the accused be enlarged on bail.
Charge number 4.
Much.
May I please your lordship, 439 bail application, also under section 20 / 29 NDPS. That is
From which PS? Bipuria.
Locking.
What was the contraband substance?
20.756 tons, your lordship.
21 kg.
20.756, lordship.
CD?
My lord.
When?
Last part of Jan.
25.
20.
Item number 5.
May I please, your lordship, madam? So this person has been arrested because of a Facebook comment he made, madam. May I take my lord to the FIR, madam? It's at page 13, madam. In the comment I can show, my lord, the page FIR is page 30. If I may read, my lord. In inviting a reference to a subject cited above, I have the honor to state that the unit engaged for monitoring the activities of Facebook activists to notice a comment uploaded by Paresh Borua, Commander-in-Chief of Alpha, madam. After stating that this SMS is not readable, madam, I have annexed the post, madam. Said one comment of one Hirokjoti Korita of Hajo uploaded a comment saying that madam, Uta bomb futai.
Pardon?
He uploaded a comment on Facebook saying that the bomb futai in Facebook, madam. Just according to the FIR was lodged, madam. May I take a note to the post, madam, kindly, madam.
At page number?
32, madam. It is a post made by one news portal, madam, Cross Current, madam, on Facebook, madam. It says, madam, Aurobindo Rajpak phone korunte চিনি নাপাম বুলি ক'লে নগাৰ দৰে সম্পাদনা আধিৰ অধিকাৰ বিচাৰিবলৈ কৈছিলো কিয় জাতিক ইমান তললৈ নমালে তেওঁলোকে জানিব আমি হৃদয়ৰ পৰা আঘাত পাইছো The lordship looks at the right side, madam, page 32. Top, madam, Hirokjoti Korita. His comment is there, madam. Parile Kubat Huta Buma Kutaidio. Only because of that comment, he has been arrested and put behind bars, madam. Because of Facebook post, my lord, can somebody be declared to be a member of a planned organization, madam? And lordship, can I turn the page 33, my lord?
Yes.
You know, Facebook, my lord, what happens in Facebook, my lord, people can react in the way they like, my lord. Somebody can laugh, somebody can show remorse, my lord. Everybody has made this haha emoji in the post, my lord.
Okay.
Kindly,
Mr.
madam.
Soma, you produced the case
Minor.
diary on
Kindly, my lord.
19, my lord.
19.
19, my lord.
From which PS?
Kamruk itself. Hazu.
Hazo.
Kindly, my lord. My lord. Cotton University graduate, my lord. He has a shop, my lord. He has a family, my lord. Only because of this one post, my lord.
We'll
Kindly,
see the
Minor.
case diary.
Can it be on 18th, my lord? Reopening, my lord. Kindly, my lord. For no reason.
19 on 19.
19.
18th is
19.
reopening, my lord.
19.
19th.
Item number 6.
Obliged.
Maybe lordship. 439 application lordship. Offense under section 21A and 21B lordship. At least this lordship case diary may be called for lordship.
Yes. Soma
My
case diary.
lord. CD, my lord.
Where?
On 24th. 24.
From which PS? Barbeta.
Kitanagar case.
Gitanagar.
What's up?
Item 7.
Commercial quantity which of NDBS, carcetate metal lordship, LCR.
Where it is pending?
Lordship Carbier long lordship, different.
Okay. Registrar shall call for the scanned copy of the record along with the case diary from the Court of Learned Session Judge. Special Judge NDPS, Karbi Anglong Defoe. Fixing the matter on
24.
24.
Much
Item
obliged.
number 8.
My lord, I will not tax your lordship, my lord. I would like to pray that the guiding may be called for, but only thing is that, my lord, similarly in a case, my lord, from the same forwarding report, my lord,
It's a APSC related case, my lord. There is already an order, my lord, so we should be taxing with that. Yes. My lord, it's a bail application 83 of 24. Achiraj Jiban Borua, my lord, versus State of Assam, fixed on 19 May.
83 of
83 of 24. BA 83 of 24.
when it was fixed, it has
It
been
is
fixed.
fixed on 19/1, my lord.
19.
Yes,
CD was called for.
yes, my lord. So in this case also CD may be called for and that with that case, my lord.
Okay. That case was arising out of the said.
Same, in fact, forwarding also same, my lord.
Acha.
2% has been arrested.
CD on
In
on-
APSC case. my
on
lord.
19. 19. CD on 19. Mr. Jetcomer learned senior counsel assisted by so and so submits that in connection with the same case, Kesari has been called for on 19.
In another case.
19/1/24 in connection with BA number 83 of 2024 and submits that on that day CD may be perused to dispose of the present application also. There is accordingly allowed. Registry shall take the BA number 83 of 2024 along with this BA number 113 of 2024. On that day, CD will be perused to dispose of the present application also.
Item number 9. This matter is of the commercial quantity and charging date also pending in Karbialam Diffu.
The same order.
Yeah, Lordship, maybe listed in first week of February also.
Why?
So, this year only, Lordship, is there, not many days. Recently, charges has been filed.
On 2nd February.
Much obliged, Lordship.
Item 10.
Okay, may I please your lordship?
Yes.
Lordship, kindly go to the FIR lordship. May I read the lordship? Lordship, FIR is on page number 11 lordship. Here lordship, most respectfully, I wish to inform that some unknown person has blocked a government road which leads to the plot of land which is in my name, on my in the name of my father, Miyadi Patta, situated in Sauguchi, and they also tried to illegally occupy the said plot of land by dumping extra soil here. Lordship.
He's an employee of this
Yes.
register office, sub-register office.
Yes, yes, Lordship. Yes, Lordship, here, Lordship, I'm praying not, I'm here, Lordship, let, for that purpose, Lordship, here, police has registered this agreement, Lordship. Police will seize the mutation part, Lordship. Police, as per our contention, Lordship, as per CRBC, Lordship, police cannot go to the seizing of mutation part, cannot investigate the revenue records. Criminal court cannot go to the revenue records.
Why?
Lordship, can criminal court examine the revenue records, Lordship, revenue part, Lordship, in the mutation case, Lordship?
No, if it is found to be necessary in order to arrive at a just decision of the case, why the court cannot call for the record?
Lordship, here, there. Court can call for the record, Lordship. So, court can call for the records of let's assume that a mutation, in case of mutation case, Lordship, it has to be overruled by the DC court. DC is the appellate authority.
No, you see, we are dealing with a bail application under 439.
Yes, Lordship. Here in this case, Lordship, I'm praying for. I'm here in this case, Lordship. I'm praying for bail, Lordship, because it is a purely of documentary in nature, Lordship.
Documentary in nature.
Yes, sir. And here, Lordship, while arresting me, Lordship, it is all sections are noticeable and though I'm in jail custody while I'm being arrested, Lordship. So I find that, Lordship, there is no necessity to arrest me, Lordship, because here, Lordship, I have given in my para, Lordship. Kindly go through to my para number 8, Lordship. Here, Lordship, in case of police required to record the certificate, arrest is necessary to prevent the accused from absconding, repeating the offense, or tampering with the evidence. Here, I'm already in jail custody, Lordship.
Whether your arrest is required or not, you are not supposed to decide. The IO will decide.
That part is not.
You see, Today morning, I have gone to the case area. And this person being a deed writer,
My lord.
he amassed property of worth 5 crores. His salary is 55,000 only. Anyway, we will peruse the
Right.
case
No,
area
no,
again.
yeah, Lordship, if considering that he is amassing property also,
Hmm.
that part will be decided by the DA case, Lordship.
By?
That part will be decided by another aspect, Lordship. Here, Lordship, my
Hmm.
contention is
No,
that
no. By practicing this malpractices, he amassed the property.
no, he amassed. It is the allegation of the police, Lordship. He might have a rich
No,
person,
the police has collected materials in the case area.
Lordship. Here,
Materials
okay,
in the
Lordship.
case.
Here, my.
Anyway, we'll call for the
My
case
lord.
area.
Lordship,
Case area on when?
24th.
My lord.
Lordship, let it be. I will not be here.
23.
Let it be on 30, Lordship.
Pardon?
30, Lord.
30.
Item 11.
Same, Lordship.
11.
Same, Lord.
Same.
Same, Lordship. Here, Lordship, and let me, one thing, Lordship. Here, Lordship, as per 92 Evidence Act, Lordship,
Hmm.
police cannot go beyond the documentary evidence. So there is no necessity for castle and my contention in that line, Lordship.
Okay, we'll examine
Hmm.
it.
Lordship.
Item 12.
Right, this is 439 application. Well, here, my lord, the petitioner, nothing has been recovered from the petition. All petitioner was present on the spot. Now, your lordship will kindly see the FIR, case 15. Well, he was unnecessary arrested.
My lord, here 21A, 21B, 27A,
I-
NDPS 29. My lord.
Well, your lordship will see page 15 is the FIR.
Yes.
Page 15, my lord.
Yes.
1-5, last paragraph of 15.
Yes.
If I read from the fourth line, last paragraph, accordingly, I introduced myself and asked the occupant for their identities. And they stated themselves Prannoy Haplongwar. This is the petitioner, man, driver of the vehicle. And number 2 is Myringa Bodo. And number 3 is Bhadrajit Hagzar. One of the occupants, Myringa Bodo, is found in an injured condition on his right hand and right leg. And when I asked him about the cause of injury, he stated that he met with an accident near Mangur. And I was carrying him to the hospital, my lord. Accordingly, I issued notice so-and-so to 3 number of occupants of the vehicle number so-and-so and conducted their body search in presence of witnesses. And during the search, your lordship will see, no such objectionable item were recovered from their possession. Nothing was recovered from this, as well as from the vehicle so-and-so. When the driver of the said vehicle so-and-so was examined, he stated that he had gone to Paibang and in the meantime,
No, but Mr. Barua,
My lord.
the fact remains that the contraband substances were recovered from your position, your vehicle.
No, my lord. Your lordship will kindly come to the
My lord.
2 incident, my lord.
Hmm.
Some 2 person waiting in the road, my lord. Your lordship will see the next page,
Hmm.
page 16. What happened? Apprehended person for their identities, they stated Rohit Nunisa. These 2 persons are from different places, my lord. And one is Kharingo 1000 of village so-and-so. The said 2 apprehended person were issued notice in presence of independent witness, namely so-and-so, and conducted the body search of 2 numbers apprehended person. During the body search, see Kharingo 1000, the police recovered 8 numbers of plastic vials. That is an individual recovery. Suspected heroin weighing only 3.52 grams, my lord. Only 3 points, small quantity,
Hmm.
3.52, that too with plastic vials, my lord.
Hmm.
That has not been measured also. And that is not from our 3 occupants. I was taking the petitioner is taking the other 2 person to hospital, and these 2 are waiting in somewhere in different on the roadside. Police suspected that we have some link, and this co-accused, my lord. This
Okay, we'll see the case area.
My lord, thereafter he is reading his another, my lord. later on, my lord, later
Mm.
part, my lord.
Yes.
Last part, my lord, 16 page.
Yes.
During the investigation, my lord. During the interrogation of Rohit Nunisha, he stated that the suspected heroine which is seized by the police from his position belongs to the Pranay Haflanga. That is the present petition.
That is the, my lord, condition that co-accused,
No, that is.
co-accused saying, my lord, that cannot
Okay,
be
the quantity is
small quantity, my lord, not
small
from me, my lord.
quantity.
Not from me, my lord, and I'm
Let the city come.
unless
My lord.
Let the city come. On 19.
My lord.
19, I will not be there, my lord. 19, your lordship will take on Monday, my lord, then January 22nd, my lord.
22nd. Okay.
But your
all right.
lordship kindly consider I am on 24 days in hospital, my lord, in jail, my lord.
Let the city come.
My
We'll
lord.
consider.
Only co-accused statement is, my lord.
No, address says that
My-
is also sufficient to keep you behind the bar.
My lord. To lead the investigation of.
During trial may not be admissible.
Yeah.
Okay, we will see.
All right.
13. This is a commercial quantity, but not charge sheeted. Kindly call for the case there.
From which place?
Is from Karbi Alam.
All of them from Qatar.
It means that Karbi Anglong
My
district is belonging to you.
Him, my lord.
A few cases.
Belongs
Lordship.
Yes, so when? CD on
My lord.
88 Lordship, commercial quantity, just arrested on 8/8.
29th, my lord. 29.
29.
29 January.
Item number 14. Much obliged, your Lordship. Much obliged.
May I please, you know, for 38 application, my lord, he is a headmaster of the school, my lord. My lord, the informants, they are residing, occupying.
CD is available.
So, you know, it is a call for this, my lord. No notice was issued on the day. Court asked me, my lord, whether it is maintainable,
My
AB, 376 AB, my lord. But in spite of all efforts, my lord, I have find out some judgments of the only in Kerala High Court where Supreme Court cases have been discussed and said that it cannot be an absolute bar that 370 AB 438 is not applicable. But may I place the matter before your lordship? My only prayer is that kindly CD may be called for and this may be given to the informant. I have made him party. It is school property as per the management order, managing committee. I went to this serve a notice to him. If he lost this false case through her daughter, who is my student.
My lord, 438 subsection 4.
4.
Yes.
My lord.
So there is clear indication in the CRPC that it is not maintainable.
That's why I have brought the judgment.
Yes.
It is the book kindly judgment.
Second petition is there. Judgment of the petition.
Petition claims. Sorry. Well, Honorable Court on that day asked me to find out any judgment. Only Kerala High Court I have got, my lord. I take your lordship, page 13, para 16, kindly. Page 13, para 16.
So credible information has been received. Here FIR is there.
Well, that's why, my lord, if you lordship may examine the matter, your lordship at liberty to reject it subsequently.
No.
There is another.
No. That is different aspect. But regarding maintainability,
Maintainable.
here it is stated that if information received by the police regarding the commission of the offense
Yes.
by the accused is credible.
Then, my lord, I take your lordship, page 20 again, my lord. Kindly come to page 20. There are
20 of?
23. That is the concluding line.
Para?
23.
Yes.
In the wake of the above findings, the question posed at the beginning of this order is
No,
answered
no, no,
negatively.
you were reading paragraph number,
23,
page
Page-
number?
20.
Yes.
In the wake of the above finding, the question posed at the beginning of the order is answered negatively. I hold that the exclusion of the clearest bail provision under 438(4) of the CRPC in respect to offence mentioned herein is not to be read as absolute, for it was discriminable in the court that the allegations are patently false or motivated and no prima facie materials exist.
No, what materials are here to suggest that the allegation level in the FIR is false?
Yes. That's right. Your
No,
lordship can come.
oh,
to the
no,
court,
what
if
materials
your
are
lordship
available?
Call for the CD, my lord. That's a notice by
No,
the
no,
court.
you, no, to call for that case, you have to satisfy that the petition is maintained.
Maintenance.
Yes. But
And
my lord,
now you tell me what materials are available with you to show that the allegation level in the
my
FIR,
lord, I tell you,
false,
take the
FIR is false.
FIR, kindly compare.
Yes, page
That is
number?
Page 11, my lord. Page 11. The humble submission of the appellant is that on 8/11/23, at about 1:30 p.m., my daughter, namely Rukhsana Begum, 10 years, returned from school by train. On query, she stated that her school headmaster, that is the aforesaid accused person, raped her in school bathroom by removing the clothes. The accused person sexually harassed my daughter on several occasions and they threatened to kill her if she discloses to anyone. The accused person tried to keep my daughter silent by offering money. Therefore, you are requested to approve action. But my submission is that I have annexed, my lord, there was the resolution. Page 17 is the resolution of the school management committee. And I am the headmaster of the school. It was resolved.
Mr. Mrs.
Yes.
The managing committee is under your control.
No. I am the school headmaster.
No, that's why, that's why,
President is there, my lord.
that's why.
They have encroached, they are residing within the school land, my lord. We have requested them to vacate the land.
Anyway, Mr. Sharma,
My lord,
we will keep the objection
my lord,
Yes.
open.
my lord.
We'll consider it. First, you call for the case area along with the medical report.
Yes. Apply.
In they will notice you will also go, ma'am.
Yes, notice I will give. Informant.
But our submission is that there is a bar, my lord, in the.
Heard, Mr. S.C. Biswas, learned counsel for the accused, applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. Pending arrest in connection with Morazar PS case number 231 of 2023 under section 376 AB IPC, read section 6 of the POCSO Act. This application under section 438 serves as prepared by applicant Mohammad Zubair Ahmed alias Mohammad Zubaid Ahmed for grant of pre-respite. The above noted case has been registered on the basis of one FIR lodged by one Rosanara Begum on 18/11/2023. Mr. B. Sharma, learned additional PP, has submitted that this petition under section 438 is not maintainable in view of the bar of section 438 subsection 4 of CRPC. CRPC. And therefore, Mr. Sharma contented to dismiss the same. On the other hand, Mr. S.C. Biswas, learned additional PP, submits that
SCB.
S.C. Biswas, learned additional, on the learned counsel for the applicant, submits that the bar of section 438(4) is not absolute. Not absolute. And in view of the judgment, view of a judgment of Kerala High Court in
Bill application number
PA
one.
number 144 of 2023. 2023. If the offense is mentioned in the FIR, if the allegation made in the FIR are patently false or motivated, and no prima facie material exists warranting the arrest of the accused. Taking this forward through the FIR, enclosed with the petition at page number 11, Mr. Mishra submits that though allegation has been made in the said FIR, yet there is a resolution of the managing committee of school dated 7/11/2023. What is the resolution?
Resolution minute at page 18 minute. Page 17 minute. And relevant portion is page 18 minute. The first proposal is decided that to construct a new classroom in front of the side of the school. Playground will reduce the size. The back side of the school is illegally occupied by family of the Ibrahim Ali, Tayyib Ali, and Jamaluddin and Kamaluddin and others. Therefore, it is essential to remove illegal encroachment from the back side of the school land to clear the half because of the land, new playground for physical as well as the mental development of the children.
So how
That
this
I want to
resolution will help you?
Beg your pardon?
How this resolution will help you?
But because I was asked by the chairman of the school management committee to serve this notice to them, and I become the victim.
Go to line 2.
And Toyeb Ali is the husband of the informant.
Line 2, প্রথম question. Of the school managing committee dated 7/11/2023, wherein it is stated that the families of Ibrahim Ali, Toyab Ali, Jamaluddin, and Muhammad Kamaluddin, and another, who were encroaching the school land from the backside, have to be
Removed.
Evicted.
Yes.
Have to be evicted. And pursuant to the said resolution, the applicant had taken step, and therefore the informant, who is the wife of Muhammad Toyab Ali, who was one of the illegal occupier of the land, lost the false case. The submission of Mr. Biswas needs further consideration. And to appreciate the same, perusal of the case diary is found to be necessary, and accordingly it is provided that Mr. Sharma furnished additional KP shall produce the case diary before this court
With
On-
medical report, madam.
on
Any day.
They will have to send notice also, my lord.
Yes, I filed today itself. 30th.
In the meantime, learned counsel for the applicant shall take step upon respondent number 2
Well, by registered post or
by registered post and also by usual process. And also through the officer inserts
Right.
jurisdictional PS.
keep block,
List the matter of when
30, 13.
30th. Number 15.
Right, please, your lordship. An application under 482 of CRPC for lordship passing of NBWA, which was passed by the learned special judge at Bomayaga. FIR lordship is at page number 8. May lordship,
where is the impugn order?
is order sheet lordship on page number 15. 225.
Page number?
Order sheet is page number 15, lordship. 15 to 25.
And who is the petitioner?
A petitioner, lordship, actually, lordship, as far as FIR goes, page number 9. I am blamed to be, I alleged to be got married to a young lady. FIR is at page number 9, if lordship may kindly turn to page number 9, lordship. I'd like to inform you that under the jurisdiction of Manik.
No. I'm asking you about the order, impugn order.
This is regarding non-bailable warrant of arrest. These are to be was lordship.
So how it is connected with the FIR?
Because if you go to lordship may kindly go to the there is a searches also. Searches was admitted on 28
No,
of
that's
2.
all right. There was an FIR and a case has been
They have
registered
been
and
declared-
investigation was carried out and you have been searched.
Lordship, they have been declared absconders.
Who declared absconder?
The honorable court has declared the
Where is the order?
Lordship may page 25, the last order. Last page, lordship.
Page number?
24, lordship, type copy. Issued.
No, originally this impugn order is dated 14/7/23.
This is the first order. That's the first order, lordship.
Hmm.
That's the first impugn order, lordship.
So by this order, warrant has been issued against you.
Lordship. Then on subsequent dates, warrant has been issued. Summons were not received by me, lordship. And so far as the allegations are concerned, the young lady is unmarried, lordship. She was on vacation for a few days. So my humble prayer before the lordship is reasonable protection to enable them to appear before the learned court on the next date fixed, that is 25 of this month, lordship. And my prayer,
What unmarried lady?
the person who
My lord, may I submit, my lord? My lord Toyabali, who is declared absconder in the search sheet, my lord, he married the child.
he is the father of the this is Abdul Rafi.
Toyabali?
Rival is the second one. Next
15, item 15.
I think it. 15 and 16 are common.
Daughter,
FFP and number 9.
Rafik.
Rafiq.
It was married by Rafik, my lord.
Hmm?
Rafik Ali and Toyabali. Toyabali's daughter was married by Rafik Ali. And both of them absconded during the time of investigation. And in the investigation search sheet, he was declared absconder, both of them, my lord. Then thereafter, NBW issued the another day. As reflected in page 25, my lord. Accused Abdul Rafik and Elias Rafik Ali and Toyabali.
The first order by which warrant of arrest was issued against you
Lordship.
is the order dated 14/7.
14/7.
Lordship, yes, sir.
So how this page number 24 is related?
These are the continuation of orders, Lordship, on subsequent.
Are you challenging those order also here?
Lordship,
Where?
Lordship,
Only 14/7, they have challenged only 14/7
and subsequent dates.
Hmm?
and subsequent date.
It's in page number 5, Lordship. Orders, page number 4, Lordship, in the petition, para 5. Thereafter, several further dates were fixed for executing the NBWDA issued against the accused person, such as on 18/8/2023, 22/9/2023, and 4/12/2023.
No,
It is-
where you have impugned those orders?
Orders are here. Orders are annexed here.
No, in your cause title? Have you mentioned those
In the
orders?
cost title manner only said that and be dated 14/7/23 and subsequent dates passed by this. Not mention the dates. Cost title.
Hmm. Yes, Mr. Sharma.
My lord, uh, their conduct is not good, my lord.
Pardon?
Their conduct is not good, my lord. During the investigation, they are not cooperating the investigation agency, my lord. And
No, but the question is, can the court issue non-bailable warrant at the very first
no,
instance?
that is
To secure the end of justice, Lordship.
too.
Heard, Mister, your good name?
DJ Nev, Lordship.
Pardon?
DJ Nev, Divyajyoti Nev.
Learned counsel for the petitioners and also heard Mr. B. Sharma, learned additional PP for the state respondent. This application under section 48, no, in this petition under 482 CRPC, under section 482 CRPC, the petitioner, namely Abdur Rafiq alias Rafiq Ali Mandal, has put to challenge the correctness or otherwise of the order dated 14/7/2023 and subsequent orders passed by the learned Special Judge Bongaigaon in Special P case number 88 within bracket M of 2023 under section 376 IPC read with section POXO Act, section 6 of POXO Act, read with section 9 of the Prohibition of Child Marriage Act, read with section 75 of Juvenile Justice Act. It is to be noted here that by impugn order dated 14/7/2023 and subsequent orders passed by the learned court below, the learned court below has issued non-bailable warrant of arrest issued against the petitioner for being shown him as absconder in the search sheet by the IO.
My lord, may having only one thing, my lord. In the 14/7/23, my lord, issue only warrant of arrest. Thereafter NBW issue. 14/7.
Warrant of arrest is not the NBWA.
My lord, here 14/7, it was warrant of arrest. Thereafter non-bailable warrant of arrest.
Warrant of arrest is a non-bailable warrant of arrest. The learned counsel for the petitioner submits that the learned court below, while taking cognizance of the offense under section 376 IPC, read with section 6 of the POXO Act, read with section 9 of the Prohibition of Child Marriage Act, read with section 75 of JJ Act, taken cognizance against the petitioner, namely Abdur Rafiq alias Rafiq Ali Mandal, and against one Toyo Bali, Zahir Ali Mandal, and Sapar Mandal alias Safat Ali Mandal under section 17/21 of the POXO Act. read with section 11 of the Prohibition of Child Marriage Act. And since the petitioner has been shown as absconder in the search sheet, the learned court below has directed to issue warrant of arrest against the petitioner. And thereafter, I order dated 28/8/2023 and 11/9/2023 and 22/9/2023 and 4/12/2023. The learned court below continued to issue non-bailable warrant of arrest against the petitioner, and that the petitioner is ready to face trial, and during investigation, he was all along available, though he has been shown as absconder in the search sheet, and therefore it is contended to allow the petition. Mr. B. Sharma, learned additional PP, has fairly submitted that the court below, at the very first instance, ought not to have issued warrant of arrest against the petitioner, though he has been shown as absconder in the search sheet. Madam, having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record. It appears that on the basis of one FIR lodged by one Janak Burman, UBC of Manikpur PS, a case, Manikpur PS case number 23/23 under section 9, 10, 11, within bracket Roman 1 of the Prohibition of Child Marriage Act was registered. And thereafter investigation was carried out. And the investigation culminated in submission of search sheet dated 2/2/2023 under section 6/17 POCSO Act under section 376 IPC and reduced section 9, 10, 11 within bracket 1 of the Prohibition of Child Marriage Act. In the said search sheet, the present petitioner has been shown as absconder. Thereafter, the learned court below, by an impugn order dated 14/7/2023, has taken cognizance of the offense against the petitioner under section 376 IPC, reduced section 6 of the POCSO Act, reduced section 9 of the Prohibition Act, and reduced section 75 of Juvenile Justice Act. And for being shown him as absconder in the search sheet, the court below has ordered for issuing warrant of arrest against the petitioner, and continue to issue warrant of arrest against the petitioner in all subsequent dates. So mention the dates. It is now well established by catena of decision of Honorable Supreme Court that non-bailable warrant of arrest should not be issued against the accused persons without availing the other tools for procuring his attendance. Other tools such as summon, notice, etc. Reference in this context can be made to a decision of Honorable Supreme Court in the case of Inder Mohan Goswami versus State of Uttarakhand. Citation. The aforementioned guidelines, the guidelines laid in the aforementioned case has not been followed by the learned trial court. By the learned court below here in this case. If we examine the impugned orders in the light of the guidelines laid down by Honorable Supreme Court in the case of Inder Mohan Goswami, this court is of the view that the same failed to withstand the test of legal scrutiny. And accordingly, the same stands set aside in quas. Accordingly, the impugned order dated 14/7/2023 and all subsequent orders stand set aside in quas. The petitioner is directed to appear before the learned court below within a period of cover
31.
and to apply for regular bail and the event of filing such an application, the learned court below shall consider the same in accordance with law. In terms of above, this criminal petition stands disposed.
Highly obliged.
Item 16.
Same matter, Lordship.
Same matter.
The petitioner is the father of the
Father, man.
alleged victim.
Same.
Item 17.
Highly obliged.
Repeat, Lordship. 438 execution, Lordship. Allegations of 420, 406, 290, 506. FI title page 11. Mary, Lordship.
Page number
11. Type copy. Very Lordship.
yes.
With due respect, I beg to state that I say the Dheeraj Soni, son of Ramkishore Sarkar, in the residence of village and post office also, in the district of also, the Haina vehicle bearing so and so, chassis number so and so, had hired on a rental basis for a season by Sakir Hussain, son of Abdul Rafiq, has mobile number so and so, in the residence of village and post office so and so, Soraidu, Assam. All out the season, he had driven the vehicle, but when I asked him about the money, he didn't pay rent of the vehicle and delayed for one or other reason, making a conspiracy possibly made me to sign one agreement. But I said I could not sign as the vehicle is not in my name. The owner vehicle is Anup Soni. I would not sign the agreement, but Sakil Hussain and his father Abdul Rafiq and Zakir Hussain started threatening me for physical assault and made me sign a agreement where he stated that the 40 AMIs of 45,000 per month shall pay by him, and till then he shall look after the vehicle. Sakil Hussain paid one month EMI of rupees so and so and stopped paying any further. When I went to the house of Sakil Hussain, then he and his father Abdullah physically assaulted me and used filthy language upon me and said he will not pay the EMI of the vehicle and threatened me to do whatever I wanted and wherever I wanted to go, and he had hidden the vehicle and shall not give me. This is the FIR given by Dheeraj, Your Lordship. Your Lordship will kindly page number, the bank account, page number 17, Your Lordship. He has been receiving the money since 2022, Your Lordship. The bank, page number 17 onwards, Your Lordship. Page number 18 there is. On the last part, Your Lordship, 28/12/22, the date 28/12/22. 18 page number. The last seven rows. It is Dheeraj, he had received an amount from the accused Sakil. Thereafter subsequent page there are various dates. It is shown in the statement, Your Lordship. The various dates he had received, even the Sony whose name is mentioned, he had also received money regularly from me. And he has taken the vehicle, and this false allegation had brought against me. At this point, I may be protected. I may appear before the investigating officer. I'll submit all the relevant documents, Your Lordship, and the statement I may allow to give my statement.
Mr. Soma,
My lord, Lordship may call for CD on 19th, my lord. Here last part, my lord. When I went to House of Circulation, then his father Abul Rafiq physically assaulted me and used filthy language upon me and said that he will not pay the EMI and of the vehicle and threatened me to do whatever I wanted. He has taken the vehicle and thereafter threatening, as per allegation, while threatening the informant made the agreement and also not given the vehicle. And also said that whatever you want to do,
okay, CD on 19.
my lord.
Lordship, I may be quoted so that I may submit all these relevant documents into it.
Thank you. This is a 430 application, FIR space 12. What has happened, 32 kettles were seized along with vehicles. I have been not named in the FIR, not been implicated by anyone.
Why you are apprehending arrest?
Lordship, I am the owner of one of the vehicles.
One of the vehicle. Let the CD come.
Now, Lordship, I'll just explain what is the, with all the, as per the act also, I have got all the relevant documents, I have brought it from the market. And I have annexed the
Okay,
document
we'll
from
see the
page
case diary.
14.
Let the CD.
14.
Short date
My lord. 22nd, my lord.
from which PS?
Nogam, my lord.
Nagaon.
22nd, my lord.
Lordship, there is a, Lordship, I'll just hear. Bokhista PS.
No.
Bokhista PS.
No.
At
Bokhista.
page 15, there is a dispute regarding ownership because I have bought the vehicle, it is another name, so I had to appear before the police.
Let the
to take
CD
justice.
come or if there is no material in the case diary.
All the accused persons
Bokhista,
have
ma'am.
already been granted bail. All the
Maybe
name accused have already been granted bail.
after perusing the case diary.
No, Lordship, because in the offense, it is not an offense under the act. With all the
You go and
registered
challenge the
documents and,
FIR then.
uh,
Go and challenge the FIR.
it is, we have all the receipts, Lordship. Therefore, under the act also, it is, will fall under the
We'll
act.
see in the light of materials available in the case diary. Let the CD come on 19.
19, my lord. From Bokhista, my lord.
Vasisto, yes.
My lord.
Deeply.
Question number 19.
May I pay the Lordship?
Yes.
Lordship, for 38 application Lordship, FIR is page 9 Lordship. Page 9. May I read Lordship?
Yes.
The informant respectfully begs to state that the above stated accused person fraudulently introduced himself as a manager of Bank of Baroda and over phone told me that he will provide CSP agent and by enticing of that collected from me through online call total rupees 35,000. 1/12/12/2023 20,000, 1/13/12/23 8,000, 1/14/12/23 7,000. After payment of aforesaid amount, the accused person demanded another rupees 20,000 in the name of document processing. Also sent an email, my email ID so and so from Bank of Baroda, wherein stated that my CSP has been approved. For starting the CSP again demanded 30,000. Therefore, I have doubted and came to know that he is a fake manager and taken rupees 35,000 from me by committing fraud. This is the case, Lordship. It's a clear allegation against the FIR name accused, and I am not the FIR name accused, Lordship. I am Rafiq Ali. FIR name accused is the Babur Ali, Your Lordship. And there is the evidence.
Why you are apprehending arrest then?
Yes, Lordship.
How
My
we
intention
involved?
is there, Lordship. Babur Ali and me belongs to the same locality. And is it about same? We know each other, Lordship. But there is a Lordship. Anybody can take that chances if he, any allegation against him raised. Then just because of escaping from his liability, he may be taken any person name of the any person, Lordship. But Lordship, in this case, Lordship, evidentiary documentary evidence is there against the FIR name accused. And only rupees 35,000 directly credited to the account of the FIR name accused, Lordship. So, Lordship, I may be allowed interim protection and the city may be called for, Lordship. City will be willing.
Are you being searched by police?
Yes, Lordship. Police search.
When?
Lordship, exactly, I have not mentioned a date in this petition, Lordship. Police was visited my house, Lordship.
But there is no reference
My lord, my lord.
of
In
you
the
in
FIR
In the FIR lordship,
My lord, in a FIR
not reference against
But-
lordship.
there may be something, my lord. there.
So rupees only,
On
the
the
rupees
CD, it will be
35,000,
different.
allegation is in
No.
respect of rupees 35,000.
Rupees 35,000, not the
Lordship.
huge amount, but
And-
from several person may have taken, my lord. Then it will be huge amount, my lord.
Lordship, it will reveal by the civil lordship, I am not the, and in the FIR lordship, there is not specific allegation against me.
From
I
city-
can correct the lordship.
Mr. No, Mr. Soma,
My lord.
we obtained verbal instruction from the IO. We will take it up at 2 p.m. Whether this person is required in connection with this case or not. At 2 p.m.
My lord.
Item number 20.
Lordship is 430 bail application lordship. This one is the second bail application lordship. Earlier was rejected lordship.
This is second petition. This is second petition.
Earlier was rejected. Kindly call for the case by lordship. Today my senior.
So what is the
Madam,
ground
no,
for
God,
filing this second petition? What is the ground
New
for
law.
filing this second petition?
Lordship, that is for this second. Police registered the case in the month of June lordship.
No. What is the ground for filing this second application? Is there any change of circumstance in your
Yes,
favor?
lordship, new circumstance. Lordship, new circumstances.
What new circumstance? What is the ground?
Said lordship, incident photograph of the informant was taken by the defendant lordship. When the informant was
No,
in.
is it the ground for filing the second application? There must be some sense of circumstance in your favor. And what are those circumstances? And in which paragraph of your petition you have mentioned it?
Paragraph 11 lordship. 10, 11 lordship.
Heard means your good name,
K. Bora.
learned counsel for the applicant, and also heard Miss. No, also heard Mr. B. Sharma, learned additional PT for the state respondent. Are pending arrest in connection with Morigao Peace case number 231 of 2023 under section 328, 342, 354, 354A, 506, 509 IPC. This application under section 438. Services preferred by applicant Mustafizur Rahman for grant of previous bail. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Srimati X name hotel on 16/6/2023. The allegation, no, Miss so and so learned counsel for the applicant said this is the second bail application, second anticipated bail application prepared by the applicant on the ground that the case was registered in the month of June 2023, and since then sufficient time elapsed, and in the meantime the investigation might have been completed and therefore the custodial detention may not be required in the interest of investigation. And therefore, it is contended to admit this petition and to call for the case hearing. Further, having considered the submission of learned advocates of both the parties, it is provided that the learned additional PP shall furnish the case hearing before this court on 24.
Item number 53.
Please, your lordship. In this case, your lordship, there was no any FIR, but the police frequently visited the house of the petitioner. And out of apprehension, this petition has been filed. And the instruction was sought, your lordship, whether any case has been registered against the petitioner.
We have not received any report also.
In the last occasion, your lordship, interim protection was granted and I was asked to file additional affidavit. I have filed that, your lordship, on 6.
So, Mr. No, from which PS?
Goroimari, your lordship.
Goroimari, lordship.
Goroimari, yes.
Gordonberry. Gordonberry is a police station or
Yes,
outpost?
yes. Now it is police station. Earlier it was outpost, your lordship, and presently.
Hmm.
Police
So at 2 PM, you.
station.
54.
Wait, this is your lordship. Lordship 438 application, the offence which have been alleged are 420 and my lord, section 81 of the Juvenile Justice Act. My lord, the FIR starts at page number 11, my lord. Page number 11, that's the FIR, my lord. Page number 14 is the functional operative part, my lord. The FIR, my lord, this has been lodged by the District Child Protection Officer of Nagaon, my lord. May I read the relevant paragraph, my lord?
Yes.
My lord, with reference to the subject cited above, I am furnishing here with order passed by the Child Welfare Committee, Nagaon, copy enclosed on 2023 in connection with this case number, which is self-explanatory along with the relevant documents. In this regard, you are requested to take necessary action as per law under section 80 and 81 of the Juvenile Justice Act, my lord. So this may be considered as an FIR. Now the functional operative part where the offences are alleged is on the next page, my lord, which is the order of the CWC. This is just the forwarding which the concerned police station has taken as an FIR. Page number 15, my lord. May I read, my lord?
Yes.
My lord. POP by GG number this and this regarding minor girl namely Rashia Rashid, daughter of Yasmina Khatun and Rashid Ali, that is the petitioner before your lordship, Islampati Hobagaon, name and address, passport document. In the order, it is mentioned that an application was submitted by Suhana Begum, who happens to be the biological mother, my lord, of the child in question, regarding the donation of the said minor girl to Rashid Ali, son of Dilawar Ali Islampati, that is the petitioner. Accordingly, both the parties were called to appear before Hobagaon TOP. The biological mother wanted to get the child back from the custody of Rashid Ali. A notary signed by Juri Bormohai, this is important, my lord, notary officer, and Rosie Hussain, advocate, has also been submitted where it is mentioned that she was unable to take proper care of her child due to financial constraint. She handed over the custody of the minor child to Rashid Ali, that is the petitioner. Rashid Ali has paid rupees 15,000 to Suhana Begum for the state purpose. Begum mentioned the name of her Laliga, who has, my lord, coordinated the deal. My lord, this is the very functional part that Rashid Ali has paid rupees 15,000 to Suhana Begum for the state purpose. This observation, they have said that we have an agreement. Now, lordship may come to agreement, my lord. It is true, my lord, that an irregular process, this adoption has been done, my lord. That the petitioner admits before your lordship, my lord. Page number 23, this agreement is there, my lord. Which agreement, my lord? I am a daily wage earner. I went to a lawyer, Rosie Hussain, the FIR named that lawyer. That lawyer said that by this agreement, you can donate and give this child. So page 23, this agreement is there, my lord. In this agreement, there is no whisper of 15,000. Just that the biological mother, she is a destitute. She cannot take care of the child. And as such, the petitioner and his wife adopted this girl in the most irregular manner, my lord. That is there. But, my lord, there is no purchasing. There is no money concerned in this, my lord. And, my lord, the advocate concerned, to whom as a layman I went, my lord, that advocate, she has been granted bail. Now, my lord, coming to the alleged offences, my lord. My lord, 420, whom have I deceived, my lord? I have adopted in a irregular manner, not knowing the advice. And my lord, with regard to the Juvenile Justice Act, the section, my lord, just to make known below, sale and procurement of child for any purpose. This, my lord, here the penalty is up to 7 years, as such making the offence non-bailable. However, my lord, in the Juvenile Justice Act, my lord, for such irregular adoption process, a special offence has been, my lord, provided, my lord. That is section 80, punitive measures for adoption without following prescribed procedure, which clearly falls under in regard to this case, my lord, that in a irregular manner the adoption has been done. For this, the punishment is up to 3 years, my lord, and it is a bailable offence, my lord. So I pray, my lord, I may be protected and the case diary may be called, my lord. That's because, my lord, 420, there is no initial deception. And if at all there is a case, my lord, it is under section 80. However, my lord, the section imposed has been 81, my lord. I went to advocate said you do an agreement. That process, my lord, I admit, my lord, before your lordship.
Mr. Soma?
The procedure is
Parva?
not working,
Yes.
but what I have found from now, my lord, bail application lordship, the procedure, there is a prescribed procedure under the CARA lordship, to which the mother child can be adopted lordship. But there they have executed an agreement and they have adopted a child also. So we'll, my lord, examine the case diary lordship, we'll see what are the, my lord, allegation and what has been found from the investigation.
For irregular adoption, my lord, that is section 80 of the Juvenile Justice Act, which is
Heard
bailable.
Mr. So learned counsel for the petitioner, applicant, and also heard Mr. Arya Barua, learned additional PP for the state respondent. Apparently arrested in connection with Nagaon PS case number 803 of 2023 under section 120B 420 IPC. Read with section 81 of Juvenile Justice Act. This application under section 438 CRPC is preferred by applicant Rosid Ali for grant of restraint. The above noted case has been registered on the basis of one FIR lodged by one Anjali Arja, DCPO, Nagaon. On 29/8/2023, the essence of allegation made in the FIR dated so is that the applicant the essence of allegation made in the FIR dated so is that one Suhana Begum, mother of a minor girl, namely Raisa Rasid, namely Srimati X, name to hotel created, namely Srimati X, name hotel. Submitted one application in connection with donation of aforesaid child to Rosid Ali on the pretext that she could not take care of the child by executing a notary deed signed by Zuri Buragohan and Rosie Hussain and handed over a sum of rupees and handed over the girl to Rosid Ali, and Rosid Ali has paid a sum of rupees 15,000 to Suhana Begum. The learned counsel for the applicant submits that the applicant attempted to adopt one child by irregular means. And as such, no offense under section 381 of the juvenile 81 of the Juvenile Justice Act is made out. And if at all any case is made out, it is under section 80 of the Juvenile Justice Act. Juvenile Justice within bracket Care and Protection of Child Act 2015, and the said offense is bailable in nature. And that the applicant is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. Whereas Mr. R.J. Borra, learned additional papers, submits that at this instance, the case hearing may be called for. Para, having heard the submission of learned advocates of both sides, the result of the case hearing is found to be necessary, and accordingly it is provided that case hearing be called for, fixing the matter on
My lord,
when
after vacation, also,
and
25. My lord.
and considering the measure of accusation and the punishment prescribed for the same, as well as the submission of learned advocates of both sides, this court is inclined to extend interim protection to the applicant till receipt of the case hearing, and accordingly it is provided that on furnishing a bond of rupees, provided that in the event of arrest of applicant in connection with Nagaon PS case number so and so under section so and so, he shall be released on interim period bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition, he shall not leave the jurisdiction of CJM Kamrup, CJM Nagaon without prior permission.
That number 55.
Deeply obliged.
Lordship in item number 53, Your Lordship. That matter is fixed today at 2, Your Lordship. I have some personal difficulties, Your Lordship. If it will be listed on 18, Your Lordship.
Pardon?
In item 53, Your Lordship, that is fixed at 2, Your Lordship. I have some personal difficulties, Your Lordship. Therefore, I'm praying for listing this matter at.
Okay, all right. We have already instructed him to obtain instruction. If no case has been registered, we will dispose of the petition today.
Problem is that, Your Lordship, I will have to leave at.
You ask someone on your behalf to remain present.
May I please? May I please?
Yes.
Forgery application, my lord, petition of before your lordship, it's a lady, my lord. The FI is page number 16. Particular, my lord. Regarding my lord, post my mark sheet and admit card of metric, my lord. What is happened? My title has been wrongly inserted in the admit card, my lord. Page number 16, my lord. FIR dated, my lord, kindly do not 11/4/2022, my lord. Now, my lord, police searching me, my lord. There is a reason, my lord, I have to police, my lord. My title is, my lord, doctor, my lord. In the admit card, it is, my lord, depicted as, my lord, Borua, my lord. Should kindly come to the page number 18, my lord. This is the, my lord, admit card, my lord. This is corrected by, my lord, Seva, my lord. There is the initial, my lord. Controller of Examination, Board of Secondary Education, my lord. Here, this is why, my lord, the informant stated, my lord, I post the document, my lord. Thereafter, my lord, I have applied for correction, my lord. My lord, after filing this, my lord, I have got the copy, my lord. This is, my lord, original, my lord. I have applied, my lord. So now corrected copy is moving, my lord. I could not elect, my lord, after filing this, I have.
Searching me, my lord, because my lord, I am a ward commissioner, my lord, there is a no confidence motion against the chairperson. Therefore, my lord, I'm not political person, my lord, the police search me, my lord. Yeah, my lord, on yesterday, yes, got my lord. There is a date, my lord, 9/1/2024, my lord, below, my lord. I have applied for correction, my lord, now got, my lord. This is the document, my lord. With I-
Bora,
Attested or,
don't take it away.
Faris made there was copy of it.
Just check, my lord. I will, my lord, furnish before the police station, my lord. I may be protected, my lord. Because my lord, FI is 2022, my lord. Under
No,
political-
case has been suscited.
No, my lord, no such. No such.
Let her appear before the IO lordship,
My
along with the document lordship.
Along with the document, I will appear, my lord. Because my lord, 2022 FI, my lord, under political pressure, now I am searching.
Heard, Mr.
My lord, T Google.
T.
T Google.
Learned counsel for the applicant and also heard Mr. Arjay Barua, learned additional PP for the state respondent. This application under section 438 services deferred by applicant Srimati Torunima Dutta,
Right.
who has been apprehending arrest under section apprehending arrest in connection with Silapatar PS case number 71 of 2022 under section 420, 468, 471 IPC for grant of previous bail. The above noted case has been registered on the basis of an FIR lost by one. Who is the informant?
Informant, my lord, Prokhanto Setia, my lord.
The basis of
Page number 16.
one complaint lodged by one Prasanto Setia
Setia, my lord.
on 11/4/2022. The essence of allegation made in the FIR dated so and so is that the applicant Srimati Torunima Dutta got elected in the
Silapathar Municipal Board.
Silapathar Municipal
Board. There's a ward commission.
Silapathar Municipal Board as ward commissioner or from ward number 2.
Hello.
From ward number 2 by filing fake educational qualification certificate. The learned counsel for the applicant submits that the applicant is innocent, no way involved with the offense alleged in the FIR, and that in the admit card, mark sheet, and in the high school living certificate, her name is reflected as wrongly reflected as Torunima Borua, but in fact her name is Torunima Dotto, and she has applied for correction of her name in the aforesaid documents, and the same has been corrected by the Board of Secondary Education Assam Guwahati on 9/1/2024, and that she is ready to cooperate with the investigating agency, and therefore it is compelled to allow the petition. On the other hand, Mr. Arjay Barua, learned additional PP, submits that at this stage, case study may be called for. Accordingly, now having heard the submission of learned advocates of both sides, it is provided that case study be called for, fixing the matter on
29/1.
29/1.
1.
Third, considering the submission of learned advocates of both sides, and also considering the documents placed on record, especially the original corrected admit card, mark sheet, and the certificate issued by the Board of Secondary Education, this court is inclined to extend interim protection to the applicant till receipt of the case diary. And accordingly, it is provided that in the event of arrest of the applicant in connection with Silapathar PS case number so and so under section so and so, she shall be released on interim period bail on her executing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. First condition, she shall appear before the IO along with the original documents. Number two. List on
29-1.
29-1.
I'm deeply obliged.
For bail hearing, item number 22.
None appears for the
May please, your lordship. Lordship, my senior is out of station. He went to Tripura High Court. Matter may be fixed after.
who is your senior?
SC Kyle, sir.
On the pair being made, no, as agreed by learned advocates of both sides, list the matter on who is that?
To due vacation, sir, lordship, last week of January maybe.
On 30,
30.
31. Item 23.
May I please, your lordship?
The CD has not been received yet.
In item number 23.
23.
I am behind the bar since 163 days, my lord.
Your good name?
P. Khakholia.
P.
Khakholia.
P. Khakoli or learned counsel appearing on behalf of Mr. S.C. Kyle, learned standing counsel for the NCB submits that case diary has not been received. Accordingly, it is provided that case diary shall be produced before this court on 19th.
Much obliged.
Item 24. Item 24.
Yes, please, your lordship. Lordship, this is an application under section 439. Lordship, the petition had served notice upon the respondent number 2, but service has not yet been completed.
Petitioner, pardon?
Petitioner has served notice to the respondent, your lordship.
When? When it was served?
Lordship 21/12/2023.
Is there any report on the record?
Sure.
Is there any report here? Office note dated 9/1/2024 indicates that service report in respect of respondent number 2 has not yet been received. Accordingly, it is provided that learned counsel for the applicant shall take fresh step upon respondent number 2 by registered post and also by usual process within a and also through the officer in sir jurisdictional PS. This the better on when.
Step. Lordship on
Next steps.
5.
Lordship,
24, 5th February.
Lordship, shortly after vacation.
Notice has to be served.
But notice has to be served. You take a step up on the respondent number 2 again. When?
Number
Covid?
on 5 February, 5th February.
Short. First or 2nd February?
Yes, Lord. On 1st February. Item
Obliged, your
25.
lordship.
Item number 25 and 37 may be taken up together. Arising out of the same PS.
Yes.
The FI is page 12, my lord.
So you are behind the bar for how many days?
For my lord, today is my 36 days, my lord.
36 days.
Yes, my lord. The allegation is that as per the FI, my lord, I have not executed the sale deed, my lord. So there is a deed of sale agreement, my lord.
to say
Whether
that-
that agreement is filed with the petition?
No, my lord, it has been seized by the police, my lord. I would see, my lord, in Cesar's, my lord, page 26, my lord.
Hmm.
It is in the case there, probably, my lord.
FIR is at page number?
Page 12, my lord. In the year 2003, my lord, the one Lucky Valley, my lord, approached this, my lord, informant, my lord, to execute a deed of sale agreement. That was not, my lord, executed letter, my lord. And thereafter, my lord, this accused petitioner and my lord, the informant entered in the deed of sale agreement, my lord, in the year 2019, my lord. I will get him page 14, my lord. From there, my lord, the allegation has started, my lord.
Page 14.
Yes, my lord. In first paragraph, that's our, my lord.
Hmm.
And the allegation is that my lord, against this agreement, my lord, I have just taken, my lord, 3,80,000, my lord, out of my lord, 5 lakhs, my lord.
So the agreement was executed on which date?
But 25/4/2019, my lord. May I read, my lord? That sir person to advertisement by Sir Atif Ali upon one Nazmul Alam for execution of deed of sale in respect of the agreement that is so and so between the adversaries said Nazmul Alam that is the accused
So
person.
the agreement was executed on 6/11/2003.
But it was executed between Latif Ali and the informant, my lord. Subsequently, again, my lord, it was executed between the accused petitioner and the my lord, informant, my lord. And against this, my lord, agreement, my lord, if the informant paid an amount of rupees 3,80,000, my lord, out of 5 lakhs, my lord. This is the consideration, my lord, amount, my lord. Now, my lord, the informant, my lord, without my lord, filing any special relief suit under special relief act, my lord, he has filed this FIR, my lord. So he has to pay the rate of the amount, my lord. But even if my lord, if he was in custody, my lord, since my lord 6/12, my lord, today is 36 days, my lord. So considering the length of detention, my lord.
Case diary is available.
Yes, my lord, case diary, my lord, we have-
Yes, so what is the stage of investigation?
My stage of investigation only to my lord to collect a report from the circle officer lordship, the who is the my actual owner of the plot of land lordship. Both of them, they are not the actual owner of the plot of land lordship. But by sitting the my lord informant, my lord, this my lord Latif is item number 37. He and this my lord Nazrul Alam, my lord, in my lord criminal conspiracy, they took money from him and executed lordship agreement, but that was not registered. They are not the owner of the landlord. Already they have, my lord, they have already, my lord, investigating officer has already, my lord, collected Domabuddin, my lord, other land record. But the final, my lord, report that is awaited. Lord. My lord, sorry,
Which report?
final report is awaited from the circle officer. The actual owner of the land. It is referring page number 28. But they are not the owner of the landlord. Yes, my lord. Page 28, my lord, kindly see, my lord. In point number D, my lord, the investigation officer collected the documents from the circle officer, my lord.
Where it is mentioned?
Page 28, my lord. This is the forwarding report, my lord. They have collected the documents, my lord, from the circle officer, my lord. It is not that they have not collected, my lord. Page 28, my lord. Last clause, page D, my lord. Clause D, my lord. In the course of investigation, the office of the circle officer disclosed and was known that the said plot of land is registered in the name of one Rama Kanta Mikir.
So how can you sell a plot of land registered in the
Now,
name of
my
someone
that
else?
is my instruction is that this person, my lord, Ramakanta Mikir, my lord, constituted me as an attorney.
Where is that attorney?
But that was not, I could not annex, my lord, because my lord,
You produce that attorney, we'll see.
he was in custody, my lord. Tell me, sir, he is out of jail, my lord. But consider the length of detention, my lord.
No length of detention. Thereafter, again, you will enter into agreement with another person and
No, but
again exploit them,
No,
exploit him.
Man, I will undertake, my lord, not to
No,
say
no,
internal
no
in-house
such
activities, my
undertaking.
lord.
So this kind of practices are going on, and the court cannot be a party to it.
Yes, that I understand, my lord. But I will undertake, my lord, I will not
No.
indulge in any such activity, my lord. So I'm saying the condition may be imposed by the so because I could not indulge in such activities, my lord. I may appear.
Kejari,
With the document.
heard Mr. S. Barthakur, learned counsel for the accused, and also heard Mr. R.J. Barua, learned additional PP for the state respondent. This application under 6/13(9) CRPC is prepared by accused Nazmul Alam alias Moon Chaudhary, who has been languishing in jail as in connection with Satgaon PS case number 226 of 2023 under section 120B, 406, 420, 468, 471, 506 IPC. It's to be noted here that above that case has been registered on the basis of one FIR lodged by one Jadunandan Roy on 6/12/2023. The essence of allegation made in the FIR dated so and so is that one Latif Ali of Sadgaon, Guwahati entered and executed an agreement with him for selling a plot of land situated at Kolita Kusi, covered by DUG number 170, pattern number 107 under Revenue District Revenue Village of Kolita Kusi, Moza Beltola, and later on Latif Ali on several times cited him in respect of registration of the said plot of land. Thereafter, Latif Ali entrusted the task to one Nazmul Alam for execution of the said agreement. Sale agreement. No, not agreement, sold it. And he took a sum of rupees 3,80,000. And both the accused persons cited the complainant by complainant for selling the aforementioned plot of land to who is none of them are owner. The learned counsel for the accused, Mr. Barthakur, submits that the accused was arrested on 7/12/2023, and since then he has been languishing in jail for last 36 days. And that the accused is the attorney holder of the said plot of land. Said plot of land, and pursuant to the said power of attorney, he entered into an agreement with the applicant, no, with the informant, and that he is ready to abide by any condition imposed by this court, and therefore it is contended to allow the petition. On the other hand, Mr. R.J. Barua, learned additional PP, has produced the case before this court and submits that the IO has collected sufficient incriminating materials against the accused. Mr. Barua further submits that the accused is not the owner of the plot of land for selling of which he entered into an agreement with the informant. And therefore, Mr. Barua has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed in record. And also produced the case area with the assistance of Mr. Barua. Learned additional PP. It appears that the plot of land measuring 9 Lassa covering duct number 170, which is make a new and carries KP number 107 new, situated in the place Politakuse, stands in the name of one Ramakanto Mekit. Ramakanto Mekit. As per the Siddha of survey place collected by the IO during investigation. Further, it appears from the case diary that the IO has collected sufficient incriminating materials in support of the allegation made in the FIR. Investigation is still going on. And enlarging the accused on bail at this stage will hamper the investigation, and accordingly the petition is dismissed. Case diary be returned.
Madam, see whether there is any statement of Ramakanta material there. See original matter plan on our madam.
Pardon?
Is there any statement of Ramakanta material original land owner madam? If he constituted me as a lawful attorney madam. That investigation is going on, doctor. I have not found any matter. But they have to.
No. The IO has collected the Siddha.
Yes, ma'am.
Copy of
that I admitted, my lord. In
Yes.
Para 6, I have pleaded, my lord, that the Ramakanta me considered me as an attorney holder, my lord. Well, my contest of whether the police has recorded the statement of Ramakanta material because he is the original landowner, my lord. If not, my lord, I pray, my lord, after this case, they may be called for, my lord. By recording the statement of my lord Ramakanta material, my lord.
No, but you are not supposed to pray in in that manner. Who will examine by the IO? And whom
I can
the IO will not
because
examine?
I'm behind the bar, my lord, since I put on my lord.
No, that's
Like
all
the
right.
matter-
You are behind the bar. But you cannot direct the IO that
That I understand, madam.
then
Since I pleaded that the person has constituted me as an attorney holder, madam.
the IO has visited the office of the circle officer,
Yes, ma'am.
and therefrom he collected the Siddha. And who is the petitioner in other case?
My lord. The other one is.
AB
Latif Ali.
number 4160.
AB number, my lord, forward is a Latif Ali, lord. Item number 37.
I'm sorry, my lord. Just this matter was called, my lord. My lord, I pray, my lord, so far my case is concerned, your lordship will kindly take up on 18. I could not go through it. It came suddenly, my lord. That's why I was not present, my lord. First call. 18 is the subject to it.
No, I don't have any difficulty, lord, because we have produced the case there, lord. You can retain the case there, that is different aspect of the method.
Well, 18, my lord, subject, it is not incorrect.
Pardon?
If your lordship will take up my matter on 18, my lord.
18.
18.
Why case there is available?
My lord,
Because
There
it
was-
has to be sent back to the IO to complete the investigation. So long the case there is pending before the High Court,
Your lordship
the
will take it up.
investigation is
Your lordship
almost halted.
your lordship will take it after some time, my lord. Let me go.
Okay, after some time.
Can you know?
All your lordship may take it up
Tomorrow, tomorrow.
Not
Saturday,
tomorrow,
take
not
those.
tomorrow. We have lot of.
after some
matters.
time, my lord.
Okay, after
Let
two,
let me go through it, madam.
okay, you go through it. As the board agreed, the petition rejected, that person is not yet examined by the IO. Investigation is going on.
And this is 5 days, lords. Behind the law.
Mr. Borba, you received the case diary?
Section motion 457 3HP.
401. What is 401?
The vehicle was stolen. The
Pardon?
vehicle is stolen. He residing the informant's house, lordship. The Neguva, lordship. The accused Neguva, lord.
Forwarding report is that page number?
Page number 15, lord. Date of occurrence, lordship, the accused.
Motorcycle was recovered? Motorcycle was recovered?
No, lordship. The accused said, the lordship, that the motorcycle, earlier he sold the motorcycle, lordship.
Oh,
The informant, lordship. Then he filed a case, lordship. He residing the date of occurrence, he residing the informant's house. It is possible, lordship, that I am residing this informant house and I am stolen the property. Attached house, lordship. The informant and the accused person. Petitioner fathers was arrested, lordship. He was released on bail.
Borba, is there any material I can say?
He has been named in the FIR. also.
Hmm. So on the same day, another occurrence took place at a distance of 400 meters from the house of the informant.
My lord.
Length of detention, lordship, any condition.
Hmm? Is there any material I can say?
So that without the case diary, also.
Pardon?
Without the case diary, also. Case diary not seen.
Case diary not received.
Fix it on Monday. Sorry, my lord. 15 lords.
Lordship's in page, police was tortured badly, lordship, page number, lordship 70. The order, lordships.
So when to be listed?
My lord,
When to be listed?
that was 18th or 19th. Lord.
Mr. Arsabaru, learned additional PP submits that he has not received the case diary. Accordingly, it is provided that recessal is the matter on 18th.
My lord,
On that day, the learned additional PP shall produce the case diary before this court.
27, deeply obliged.
May I please, your lordship? Lordship, although the case has been listed in hearing column, but probably my lord, LCR was not called for because on last occasion, unfortunately, I was even absent.
It is suscited.
Suscited case is behind the bar.
Acha. Okay, recessal call for the scan copy of the record from the court of where it is pending.
It is my lord.
Session Judge Baksa
Yes, Baksa Motion.
from the court of learned NDPS. No, no, from the court of learned Special Judge NDPS Act. Baksa.
Baksa.
Session case number 03 of no special NDPS case number 03 of 2022 under section 20C. When?
On 30, 31, 24.
30.
Item 8,
Published.
Yes.
439, my lord, arrested on 31st 12.
31st 12.
12, my lord. This is a deputy director of revenue education, my lord, this poor, my lord. What happened, my lord, this lady staff, my lord, she came to invite him, my lord, and wished Happy New Year. He also exchanged it. That way, maybe something, as per FIR, my lord. But one the question, but in the office, you must kindly say page 14 in the FIR, my lord. Page 1. 354, my lord. If it would be
Page number 1.
114, 14, 14. FIR.
Orla?
my lord, we have received the case diary. Lord.
Yes.
We have received the case diary. Lord.
Actually, my lord, it ought to have been registered under this act, my lord.
So, what is the stage of investigation?
The extent of investigation, lordship, my lord, 164 statement recorded,
Everything
lordship.
is recorded, nothing.
Then lordship witnesses examined, my lord, then my lord, medical also done, lordship, medical she refused, lordship.
I'm only matter custody period of detention, man. Nothing remains to investigate.
Investigation progress, lord.
No, further detention or whether required in the interest of investigation.
There is no, my lord, report of the IO, then further investigation is pending, lordship, but I have submitted, no, these are the investigations done by the IO, lordship.
Heard Mr. S.R.S. Sotor, learned senior counsel assisted by Mr. So learned counsel for the accused and also heard Mr. R.J. Gora, learned additional PP for the stateless loan. Gora, 160%. This application under section 439 CRPC is prepared by accused Amir Hussain, who has been languishing in jail as in connection with this court PS case number 2364 of 2023 under section 354, 354A, 354B, 509 IPC. Is to be noted here that above noted case has been registered on the basis of an FIR lodged by Srimati X, name withheld, Junior Assistant Director, Directorate of Elementary Education, Assam, Kailipara, on 30th December 2023. The essence of allegation made in the FIR dated so and so is that on 30th December 2023 at about 3:45 p.m., she went to the chamber of the accused to invite him to a farewell of Mayuri Pujari. Mayuri Pujari, who was supposed to retire on 31st of December 2023. And then the accused caught hold of her hand and raised her towards him and molested her by touching her different parts of the body. Mr. Asaris Chaudhary, learned senior counsel for the accused, submits that the accused was arrested on 31/12/2023. And since then, for last 13 days, he has been languishing in jail as a 13 or 12? 12 days he has been languishing in jail as a. Further, Mr. Chaudhary submits that given the nature of accusation, on the nature of allegation, further custodial detention of the accused so may not be required, and as such, Mr. Chaudhary contended that the accused may be enlarged on bail. On the other hand, Mr. R.J. Barua, learned additional PP, submits that the investigation of the case has sufficiently progressed as indicated in the case date. The statement of the victim girl has been recorded under section 161 CPC and some witnesses are also examined. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Barua, learned additional PP. The case diary indicates that the accused was arrested on 31/12/2023 and since then he has been languishing in jail as a. Case diary also indicates that the IO has achieved sufficient progress in the investigation of this case. And in that view of the matter, further custodial detention of the accused, in the interest of investigation seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security of lying amount to the satisfaction of the arresting authority.
CGM Kamrup Metro.
No, to the satisfaction of the learned chief judicial magistrate Kamrup and the accused being enlarged on bail. The above privileges, however, subject to the following two conditions. Number one, he shall not leave the jurisdiction of CGM Kamrup without prior permission. And he shall not make any attempt to influence the witnesses. In terms of this, BA instance dispose of city related.
Item number 29. Obliged. Madam, my have a prayer, madam. Item 41, you kindly accommodate today, all the item 41, my. Only today, my lord. If possible, tomorrow or.
Tomorrow not possible.
Only, madam. Today I have to go some medical attendant, my lord, for right now, my lord. May not be that, my lord.
Okay, on the appearance made by Mr. S.R. Chaudhary, learned senior counsel for the accused, list the matter on 19,
Any day after we, my lord. 19th or 20th.
22nd, 22nd.
My lord. Obliged.
29. That is a lot. In this case, the petitioner was an interim bail, my lord, and city was called for.
Case that is not received.
For last 7 8 days, city was petitioner stated.
From
that
which
reported
place,
by
Mr. Barua?
My lord, there is a report, report has come.
the- It also reported.
Case, my lord, Kerala PSK that has been transferred to Lanka PS. Lord.
Nagaon,
Lanka PS.
Lanka,
Lanka. So, my lord, we have to call for the case that is
from Lanka PS.
not come. Lanka PS.
Okay, what is the number of Lanka PS?
That is not mentioned, Lordship, only my lord.
Then how can I call for the case diary? If the number is not there?
My lord, that we have to-
Because because the case has been transferred, definitely there will be new number
New number.
in Lanka PS.
Because this report is provided by the my lord Kerala PS. Lord. There is a name suggest we have transferred my lord to the Lanka PS. So we have to my lord obtain the instruction. from
Mr.
the Lanka-
Sonda, you
Section
can
is 40.
obtain information from the CJM Huzai. Because without the permission of the CJM Huzai, they would not do perhaps.
My lord.
From the court of CJM Huzai, you can obtain the information. What case has been registered in the Lanka PS? Well,
Otherwise, this case is section, registered under section 406 of the criminal breach of trust.
that's all right, but if I pass the order on that basis, then you will not be able
Yes.
to derive the benefit because
Lordship, yes.
case number is different.
Yes. Well, I'll take.
Okay,
Number to the
Mr. RJ Borua, learned additional PP submits that though the case diary was called for, he has not received the same. But as per his information, Kerala PS case number 115 of 2021 under section 406 IPC has been transferred to Lanka PS. In view of above, it is provided that learned counsel for the applicant shall obtain necessary instruction and apprise this court on next date. List the matter on
25.
25
February, my lord.
February. Okay.
5 February.
Obliged.
February. Item 30.
Interim maybe question, my lord.
Is there any interim?
Yes, ma'am.
Okay, till returnable date, till next date, interim order, first earlier shall continue.
My lord, here I have received the information, my lord. Search sheet submitted.
This matter,
My lord, 30. In
at-
the
item
morning
number?
period mentioned, my lord.
Item number 30.
30, 30, my lord.
30,
My lord.
search it submitted.
Search sheet submitted against the present petitioner also, my lord.
Mm.
And under section 120B, 384, 420, 500, 413 apiece.
120B,
384, 420, 500, and 413.
Other accused, all the accused persons are being bail, my lord.
Heard Mr. S. Oduri,
Yes, Islam.
S.
Islam.
Islam Learned Council for the applicant, and also heard Mr. B. Sharma, Learned Additional PP for the state respondent. This application under section 438 service is prepared by applicant Mohammad Rasidul Haq, who has been apprehending arrest in connection with Fakriya grounds PS case number 71 of 2023 under section 120B 384 420 500 IPC. Is to be noted here that above noted case has been registered on the basis of an FIR lodged by one Rahmat Ali on 26/4/2023. The Learned Council for the applicant submits that this court was pleased to extend interim protection to the applicant by order dated 22/8/2023 in person to the said order. You have appeared before the IO?
Yes, my lord. His statements has already been recorded. My lord.
He has appeared before the IO and his statement is also recorded, and he has been cooperating with the investigating agency, and therefore it is contended that the interim order dated 22/8/2023 may be made obsolete in the same terms and conditions. On the other hand, Mr. B. Sharma, Learned Additional PP, submits that he has received the case diary. No, he has not received the case diary, but as per his instruction, the IO has completed investigation in late charge sheet, being charge sheet number
80/23,
80/23 dated
31/10/23.
under section 120B 384 420 500 410 IPC. In view of the submission of learned advocates of both sides, this court is inclined to dispose of this anticipated bail application by directing the applicant to appear before the learned court below and to apply for regular bail. In the event of filing such an application, the learned court below shall consider the same in accordance with law within
30 January.
30 January. Till then, interim order dated 22/8/2023 is then extended.
31.
My lord, here CD not received, my lord. They are interim, my lord.
Mr. B. Sharma, Learned Additional PP, submits that he has not received the case diary. Accordingly, it is provided that Mr. Sharma shall produce the case diary before this court on
I'm looking for my lord. 2.
2nd February.
on
2/2.
2nd February.
2nd February.
Till then, interim order passed earlier shall continue.
Item 32.
In this case, Lordship, CD has been taken by the investigating officer, Lordship, some due to some urgent purpose, Lordship. So, my lord, it will produce the case that next day, Lordship, this person is your interim.
Mr. Arjay Barua, Learned Additional PP, submits that though the case diary was received here in this case, the same was taken back by the learned by the investigating officer and not received back till date, and press for granting him some more time to produce the case diary before this court where is allowed. Place the matter on
21 or 22 or 23.
23. Till then, interim order dated 29/9/2023 stands extended. How many cases are pending against this person?
My lord, till now 2 cases.
4 cases.
2 cases.
2.
Yes, my lord. Yesterday, day before yesterday, one case is rejected by your lordship.
Till then, interim order pass earlier shall continue.
Item 33.
438 application lordship. Here, some rights were recovered from the godown of the present petitioner lordship. And subsequent bail application lordship, and it's page 33 lordship. Page 33, paragraph 7 of your lordship's order.
This is second application.
And subsequent, all those lordship receipts were earlier also annexed with the petition but could not produce for your lordship. Pointed out before your lordship. And my submission to your lordship is that already lordship, those rights were recovered and lordship after a lapse of time, he has not involved in similar activities also. Earlier, no antecedents. And essential commodities act is there, that is bailable lordship. 420-406 will probably not come. Therefore, bail may be considered.
This is second application or third application?
Third application. First application was
So
rejected.
what is the ground?
My ground page, paragraph 7, your lordship will find. Page 33. 33, your lordship observed that though I have produced some documents relating to sale purchase of those rights, but that is at belated stage. And my case is that in the earlier applications also those documents were enclosed. Therefore, lordship has directed to produce or dispose of applications, and it is there lordship. But there was a pointed query from this court, but earlier counsel could not point out before the court that that documents is enclosed. Therefore, in the page 27, your lordship will find that there was a pointed query from the court. But in the said application, those documents were there. Page 27 for a moment, lordship may kindly see. Page 27. In middle portion, your lordship will find to a pointed query. The learned counsel for the petitioner has failed to reply as to how the PDS rights was stored in his house of the petitioner and was under his possession. But in the said bail application, if your lordship peruse that AB number 4281 of 2021, your lordship will find that those sale purchase receipts were there, but the counsel could not produce it.
No, whether PDS rice can be sold.
No, he has lordship rice mill lordship, and there was rice. Aware that those are PDS rice. Even in the FIR also, your lordship will from the rice mill and come go down, it was recovered. Page 14, your lordship will find. Page 14, last paragraph. And trade license is also there, lordship. He is running this rice mill since long. There was no complaint except this present case, lordship. Even after this case also, there is no other case against the present petitioner.
Page number 14.
14, last paragraph. Conducted raid in the rice mill can go down premises of Rohim Ali. And page 13, your lordship will find he is a he has trade license also for running that rice mill.
No, you have trade license, but you have you cannot utilize those no that trade license to sell purchase this PDS rice.
He is a bona fide purchaser, lordship. That therefore, lordship, I have produced that document, lordship. Page 24. Your
No,
lordship will
bona
find.
fide purchaser means whether those PDS rices are available in the open market for purchasing.
Those rice were, lordship, not PDS rice, but the bags which he have purchased from the local market, lordship. That therefore, lordship, they have found those bags. But the rice he has purchased from the local market. That is local rice. Page 24, lordship. Will find. That's
Mr.
60
Soma,
pages.
you received the case diary?
My lord. And my lord, I also received one report, my lord. Yet, my lord, in one occasion, my lord, the court has asked us to verify the genuineness of the annexure 3, my lord, in page 24, my lord. Your lordship observe in your lordship order in page in paragraph 7, my lord.
Page 30.
Yes, my lord. 33. Page 33. So that may I place it before your lordship?
That actually, that receipt is not genuine, my lord, as per our finding. And that is subsequent development.
So, was there any direction of this court to verify the genuine?
My lord,
my lord,
but date, my lord, I don't know, my lord. But in our, we have noted it, my lord.
and on the same date, lordship, another FIR was lodged.
Where such observation was made?
Your lordship, page 33, my lord,
Hmm.
para 7,
Hmm.
regarding death, my lord, death report, my lord. Genuineness of the aforesaid sale and purchase receipt.
Hmm.
And if the same being exists on 24/11/21, the petitioner could have furnished regarding death, my lord, regarding that regarding that sale and purchase receipt, my lord.
Hmm.
Petitioner claim it as genuine, my lord, but we have verified it and found it, my lord, not genuine. And some statement also recorded in that connection.
So that document was enclosed with this petition.
Yes,
At page number.
24.
24 page, my lord, and except 3.
So now you are in a precarious position. There is statement of the person who has allegedly issued those certificate.
So whatever is there, lordship, I will face that as this is a case of 2021.
Now we will issue a direction to register a case against him. For making fake documents.
Whatever is there, lordship.
Also we will file a case against you. This 340 or like that section CRPC.
My lord.
Because you have filed an affidavit here, that affidavit, contention of that affidavit is misleading.
Yes.
Mm.
Regarding that genuineness, lordship, that he will face the trial, lordship, in the during the trial, lordship. Because lordship, he has to cross-examine those witnesses, he has to, lordship.
No, at this
give
it says the
evidence,
question of
lordship.
cross-examination does not arise.
When earlier, lordship, the bail, those records were produced along with the earlier bail applications, they never, lordship, said that these are not genuine documents.
But it is subsequent development, my lord. It is in November, my lord.
No, this was a place in the year 2021 when initial bail application was filed, lordship.
No, initially no such observation was made by the court. Perhaps because of the observation made in this bail order at page number 33, they got it verified.
But to that, lordship, I have no access, so I cannot submit on that aspect, whether how they have made the inquiry. lordship.
Okay. This is fourth application. Heard Mr. A. Ahmed, learned counsel for the applicant, and also heard Mr. P. Sharma, learned additional PP for the state respondent. This fourth anticipatory bail application is preferred by applicant.
Rohimuddin, Elias Rohimuddin.
Rahimuddin alias Rahim Ali, who has been apprehending arrest in connection with BIEOPS case number 23 of 2021 under section 120B for 2406 IPC, read with section 7 of EC Act. The above noted case has been registered on the basis of an FIR lodged by one Dilip Dekka, Superintendent, FCS and CA on 1/12/2021. The essence of allegation made in the FIR dated so and so is that acting on a tip-off, the informant along with other staffs conducted raid in the rice mill cum Godam premises of the applicant situated at Blaze Kabaitari, Part 4 under Jugigopa Police Station of Bongaigaon district and recovered huge quantities of PDS or like TPDS rice in FCI mark jute gunny bags along with FCI tag and yellow colored plastic bags. And at the relevant point of time, the applicant was not present in his rice mill, in his mill premises, or in his residence. And his mother, wife, and children were present there. And on being asked, they failed to produce any purchase memo, trade license under concerned Gaon Panchayat, etc. for storage, sale, and dealing license of PDS rice at his Sopkam Godam premises. And during inquiry, 60 numbers of yellow colored PDS public TPDS rice, 30 quintal, 200 numbers of empty jute gunny bag along with FCI tag and 3 numbers of 220 capacity iron barrel of blue dyed SK oil. Total 660 liters have been found and seized in connection with and she is preparing seizure list. Mr. Ahmed, learned counsel for the applicant, submits that on 3 earlier occasions, this court was pleased to dismiss the anticipated bail application filed by the applicant. And the ground for filing this fourth application is that the court has not considered one sale purchase receipt produced by the applicant in his bail applications, and therefore he again preferred the fourth application on the basis of the aforesaid documents. Mr. Ahmed further submits that the applicant has trade license and he purchased the seized rices from the local market, and he is no way involved with the offense alleged in the FIR, and he is ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP, has produced one verification report submitted by the IO of this case, pursuant to observation made by this court in the order dated 18/10/2023. And perusal of the report indicates that the IO has personally verified the genuineness of the sale purchase receipt bearing number 119 as annexer, which was enclosed with the petition as annexer 3 at page number 24, and found that the sale purchase receipt is fake and was not issued from the market. And he has verified from the market in charge, Mohammad Atwar Rahman, who stated before him that he never issued any such receipt during his tenure from 1/7/2019 to 30/6/2020. And therefore, Mr. Sharma submits that the petition may be dismissed, as the ground for filing this fourth application is only on the basis of the said sale purchase receipt number 119. Having heard the submission of learned advocates of both sides, I have gone to the petition and documents placed on record, and also perused the report submitted by the IO. It appears that indisputably 3 bail applications filed by the applicant, 3 anticipatory bail applications filed by the applicant were dismissed by this court after perusing the case data. The only ground for filing this fourth application is the receipt number 119, allegedly issued by one Atwar Rahman, which is annexed with the petition as annexer number 3 at page number 24. And it also appears that by order dated 18/10/2023, this court was pleased to issue direction to the learned additional PP to hand over a copy of the sale purchase receipt to the IO concerned and to get the same verified. And to get the same verified, and to get the genuineness of the same verified. And during verification, it has come to light that exhibit that the sale purchase receipt number 119 is a fake document. In view of above, this court is of the view that this fourth anticipated bail application is not maintainable. And therefore, this court is inclined to dismiss the petition. However, liberty will remain with the investigating officer to proceed against the applicant in connection with filing of fake document before the court. In terms of this AB instance disclosure,
Obliged.
the report submitted by the IO shall be part of the record.
Obliged.
Lordship, notice has been issued against the petitioner. This is a domestic violence case. Notice has been issued against the petitioner.
Pardon?
That's why.
Domestic violence, whether warrant has been issued against him. Then what urgency is there? 18 or 19, you can choose any date from. You inform the court master. Yes, Kobi?
Timing item 19. Timing item 19.
Yes.
I want to mention one item for Azan matter on 18.
18.
Criminal petition.
Criminal petition. What urgency is there?
No. They already issued the bailable warrant.
Available warrant, yes.
No,
You can
your
go
lord-
and court will enlarge
they-
you on bail.
No, your lordship, they are residing in the outside of India. There is a person,
Then where is the immediate apprehension of arrest?
24.
You go and appear before the police officer and he will grant you bail.
Your lordship, I can on 18.
18 not possible. 18 we have some other matters.
26.
Thereafter, any date you can choose. After 18, any date you can choose. Not on 19th. Yes, next. Mr. Barua,
Mr. Sharma come with it.
you got
Sharma come,
information?
Mr. Sharma. Mr. Sharma come with it.
Sharma? Yes. Okay, this volume is. So search sheet is submitted here.
No, my lord.
What is it?
My lord, here in the FIR, his name was not there, my lord. That's why lordship was pleased to call for a report from IO, my lord, whether his involvement and others, my lord.
Yes.
Yes. I'm also saying that, Lordship. Report may be called for from the IR, Lordship. In the meantime, interim protection may be given, Lordship. Specific allegation is not against me, Lordship. Not there, Lordship. Moreover, Lordship, section 66, the I.
No, first lordship will go to the report, my lord. last but one param.
So we'll call for the case there,
Minor.
no interim relief at the
Minor.
business.
In this
As
case,
per this report, you were the kingpin of the
Minor.
offense.
no, Lordship.
He's running the minor business minor. Just the.
Yes, Lordship, there is Lordship, one company, registered company, Lordship, but Babur Ali was not the part of that company, Lordship. I have also some.
All of you
He
were
has the
in
Rafiq Ali. He has the-
handling gloves.
I am the Rafiq Ali, but allegation is that Babur Ali. with
Let the
organization
city
of
be
minor-
called for fixing the matter on.
Lordship,
Sharma?
interim protection may be given.
No, no.
Lordship,
From Morigaon minor.
I am not
24
involved
minor.
with this.
24 minor.
24.
20.
Okay. Having regards to the nature of accusation and the punishment prescribed for the same,
Lordship, may
and also the
Can you
role
put
being
8,
played by the
9,
applicant in view of the report dated 11/1/2024 submitted by the IO, this court is of the view that interim protection at this stage cannot be extended to the applicant.
Timing item 53.
Minor kept as a part of the record minor.
The report submitted by Mr. Sharma shall be part of the record.
Okay.
Madam, 53 Lordship, Lordship may kindly produce the order dated 28/11/2023 Lordship.
I'm sorry, Lordship. In the meantime, I may be allowed to file a detailed affidavit.
Where? You
I
can
think-
file any number of affidavit. Permission of the court is not required.
Madam, Lordship may kindly produce order dated 28/11/2023 Lordship. Passed in this case.
Yes.
This is the position Lordship. Earlier.
No, whether you have received
Madam, we have
any.
not been able to contact the pilot officer inside Lordship. Or any police officer, madam. Lordship grants like.
Mr. Borua learned additional 50 submits that though by order dated 28/11/2023, he was directed to obtain necessary instruction from police in respect of searching the house of the applicant. Yet he could not contract the officer in search concerned PS and therefore prays for granting him some more time. Here is allowed, list the matter on when.
Madam, any date Lordship, only madam, a copy of the order may be furnished to me Lordship, so that I can madam forward it.
Okay, when?
25.
25.
25. Till then, interim protection granted to the applicant by order dated 22/11/23 shall continue. A copy of this order be furnished to Mr. Borua, learned additional PP for doing needful.
Obliged.
Item number 34.
Lordship, CD is not available.
Yes, that is not visible.
Mr. RJ Borua, learned additional PP submits that case diary is not available and press for granting him some more time. Fair allowed. List the matter on when.
Lordship, I have
Pardon?
interim.
Madam,
I have interim.
22.
First February.
First February.
1st February. Till then, interim order dated 15/11/2023 shall continue.
36. 36.
None appears for the petitioner. Are you for the petitioner?
Yes, your lordship, case diary is not there.
Yes, that is received in 36.
So maybe possible for timing, your lordship.
Why? Why?
The senior
Who is your senior?
TJ Mahanto will appear.
37.
Please, your lordship, lordship may kindly take up the matter after some time as my senior is not at fault.
Madam, I am not well today Lordship. Can it be my lord? Madam, tomorrow Lordship.
Tomorrow?
So I want to leave that.
Tomorrow, we
7
have
meters
more
to
than
go.
60 meters.
Lordship, in that case, if the matter could be
You-
fixed out to me.
You can entrust someone to look after the case diary.
My lord, Lordship has already produced the case diary. Lord.
Okay.
That came.
Item 38.
Did your score down?
My lord, in 38, my lord, we have not received the case there, my lord.
Mr. B. Sharma, learned additional PP submits that he has not received a case series. Accordingly, it is provided that Mr. Sharma shall produce the case series before this court on when?
24th.
It also appears that no notice was issued to the respondent through the officer in search concerned PS. No, through the investigating officer, yet no report has been received. The learned additional PP shall do the needful in this regard in respect of the in view of the order dated 20th/12/2023. Board, Sharma, you confirm it from the IO whether notice upon respondent number 2 is served or not. List on when?
24.
24.
My lord. 39.
Yes. Locker, you received the case.
I received it.
So what is the allegation?
My lord, allegation has been brought by the complainant that his signature has been taken forcefully in an agreement for sale of land, my lord, which is quite false, my lord. Your lordship may kindly see the nature of the allegation, my lord. At page 11, my lord.
You have filed additional affidavit. No.
No, my lord.
What's up? You are referring to?
My lord, at page 11, my lord, the complaint petition filed against us, my lord. My lord, the main fact is that the complainant has agreed with us to sell a land, my lord, a plot of land, my lord. And that the agreement was signed by him, my lord, voluntarily. There is no any coercive method, my lord. Now, thereafter, after 6 months, he has filed a complaint, my lord. Before that, my lord, Vichar was held 3 times, my lord, by the petitioner, my lord. And it was declared by the committee of the Vichar, my lord, that he must execute the sale deed, my lord. To avoid from that, my lord, he has filed a complaint petition, my lord. In this respect, we have filed a title suit before the learned Yusuf Khan Hailakandi, my lord, for specific performance, my lord. So to save himself from that, my lord, filed this complaint petition, my lord. Not only from me, my lord, he also taken from another person who is the accused number 2, my lord, who is not before your lordship today. At page 11, my lord, your lordship, my, and it was thereafter registered after 3 months, my lord. Complaint has taken from petition number 1 lakh rupees in the after signing in the Bainanama, my lord. Complaint petition at 11, page number 11. Title suit has been filed by the petitioner, my lord. The complaint petitioner has taken 2 lakh from the 2 persons, my lord, for selling the plot of land, my lord.
Yes.
The city lordship that he sold one plot of land lordship, jointly sold one plot of land lordship, and that land has been purchased by the petition number 1, Nur Alam lordship, and another person lordship. Thereafter, as a consideration amount, he received 2 lakhs rupees, and thereafter he,
Pardon?
as a consideration amount,
Hmm.
he received 2 lakhs rupees, and
Hmm.
he kept it in the hands of petition number 2. And thereafter, when he was willing to go for a house, then he went there to get his money back. Then he gave him only 5,000 and said that you have no other money with me. That is the thing also. Complainant statement, from the statement of the complainant, it is nowhere stated, let's say the signature are forged. That is not there in the statement of constituent statement also. Forging of signature is not here.
Hmm. So there is no
Only
matter.
regarding money, lordship.
Uh.
Only regarding money, that he kept it in the hands of petitioner number 2. And when he asked him to return the money, he did not return. He only gave him only 5,000 rupees. That is the case, lordship.
So he's on interim basis.
No, my lord, interim was not done.
What's so there is no material against him.
That is, witnesses also stated the same thing, lordship, that he kept 2 lakhs rupees in the hands of petitioner number 2, but he did not return.
Hmm.
My lord, sorry, my lord, I have to submit my lord. It is completely different from the statement in the complaint petition.
So initially Bainanama was executed with Abdul Karim, Qazi Abdul Karim.
It's my lord, Qazi Abdul Sattar, my lord.
Sattar or Karim?
Abdul Karim lordship.
Oh, yes, my lord, yes.
Qazi Abdul Karim.
Yeah,
And
Qazi
the
Abdul-
consideration was fixed at rupees 2,16,500.
Yes, ma'am.
And thereafter another Bainanama was prepared
Yes, ma'am.
by the accused persons.
Yes, number 1, ma'am. Agreements were signed by them.
By fraudulently taking his signature.
Yes, now he is stating my.
Pardon?
The complainant is stating my. It is voluntary. Yes.
Heard Mr. Your good name?
SR Borbuyan.
SR?
Borbuyan.
Borbuyan, learned counsel for the applicant, and also heard Mr. P.S. Locker, learned additional PP for the state respondent. Apprehending arrest in connection with Algapur PS case number 165 of 2023 under section 120B 406 416 420 427 468 34 IPC. This application under section 438 services prepared by 2 applicants, namely Qazi Noor Hussain and Aftabuddin Qadi, for grant of previous bail. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Abdul Sattar Qadi on 16/10/2023.
No, my lord.
When?
It was. Yeah, by on in 19/7.
On 19/7/2023. The essence of allegation made in the FIR dated so and so is that the informant Abdul Sattar Qadi entered into an agreement with his nephew Qazi Abdul Karim at consideration on fixing the consideration at rupees 2,16,500. But the accused persons, namely Qazi Noor Hussain and Aftabuddin Qazi and Mujibur Rahman Chaudhuri, have prepared two bainanamas and fraudulently took his signature without reading the same to the informant. The learned, they are also nephew.
Yes, nephew, my lord, of the same.
The learned counsel for the applicant submits that the applicants are also the nephew of the complainant. And there was dispute regarding this payment.
The payment has already been 1 lakh by each, has been made, my lord. Now
And-
he is trying to avoid himself to execute the sale deed, my lord.
Oh, this
Yes,
informant.
my lord, that is a title suit has been filed by the
Submits that.
accused petitioner number 1, my lord, for specific performance, my.
Submits that.
Your lordship may kindly help me look
Submits
at
that
page
the
22, my
informant.
lord, at page 22.
Informant has agreed to sell the plot of land to the applicants. And he also received the amount,
Yes, he received the amount. 1 lakh.
received the amount, but he failed to execute the sale deed
Yes, my.
in favor of the applicants. And that the allegation level in the FIR is false and that they are ready to cooperate with the investigating agency and therefore it is contended to allow the petition. On the other hand, Mr. P.S. Locker, learned additional PP, has produced the case area before this court and submits that submits that the informant has already received the amount. That is the material available in the case area.
He received the amount and he kept it again in the hands of petition number 2 and told that I will take it after some few days. Then when he went for returning his money, then he did not pay him. Then he request to return.
If it is so, my lord, there is no connection with the accused number 1 and 2, my lord. They were present in the.
And he returned the amount to whom? Informant has returned the amount to whom?
The informant has may I
He
repeat?
received the amount.
He received the amount.
He
and
returned
kept-
the amount to whom?
He kept it. He did not. He received, but he did not keep it with him. He keep it with in the hands of again petitioner number 2. This
Acha.
petitioner number 2.
Acha.
Thereafter, when he once he went,
Submits that the informant has received the amount, but he kept the same with the petitioner applicant number 2.
let's say Abdul Mannan.
Applicant number 2. Aftabuddin Qazi.
Let's say
Aftabuddin Qazi. And thereafter,
when he asked his money back, he did not. He refused him to. pay.
and when the informant has asked Aftabuddin Qazi to return the amount, then Aftabuddin Qazi refused to return the same. It also returned the same, and that in view of the materials collected in the case study, the learned additional PP has opposed the petition, having heard the submission of learned advocates of both sides. I've gone to the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Locker, learned additional visit. It appears from the case diary that the matter relates to selling of a plot of land and execution of sale deed. And in connection with same on title suit, being title suit number, what is the number?
99 of 2023, my lord, yes, page 20.
99 of 2023 has also been filed before the court of
Court of Munsef 1, Hailakandi.
before the court of
Munsef 1, Hailakandi.
Munsif number 1, Hailakandi. And the same is now pending for adjudication. In view of the nature and gravity of the offense and the punishment prescribed for the same, and also in view of the fact that civil suits are pending between the parties, this court is of the view that custodial interrogation of the applicants may not be required in the interest of investigation. And therefore, this court is inclined to grant the privilege of prior bail to the applicants, and accordingly, it is provided that in the event of arrest of the applicants, namely so and so, shall be released on prior bail under executing a bond of rupees 50,000 each with 1 surety of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. Last condition, they shall not leave the jurisdiction of CJM Hailakandi without prior permission.
AB, my lord. Arresting authority, AB, my lord.
No, that is there, but condition is imposed that he shall not leave the jurisdiction of CJM Hailakandi without prior permission.
Yes.
Item number 40. Item number 40.
City receivers.
May it please your lordship. My lord, 438 application, my lord, second application, my lord. Earlier, my lord, rejected on 6/10/2023, my lord, at page number 18. My lord, as per the FIR, my lord.
What is the second ground?
My lord,
No, what is the ground for filing this second application?
ground is that, my lord, earlier, my lord, the common application was prepared for several petitioners, my lord. So the individual contention of the present petitioner, my lord, may not have been properly placed, my lord. Now, the petitioner is a, my lord, registered, my lord, he planter, my lord. And, my lord, the thing is that the earlier, my lord, the FIR, my lord, was registered on 25/8/23, my lord. Thereafter, my lord, around 5 months have elapsed, my lord. And the sections, my lord, the provisions of law, my lord, carry maximum penalty up to 3 years, my lord. So, my lord, and also, my lord, all the name accused persons, my lord, who were named in the FIR, my lord, they have also been released on bail. The name of the present petitioner, my lord, does not find mention either in the preliminary report, my lord, preliminary inquiry report, or in the FIR, my lord. So, my lord, my submission is that, my lord,
Mr. Das, so this court has gone through the case diary
yes,
and satisfied that there are prima facie materials against him in the case diary. That's why earlier petition was dismissed.
yes, but the thing is that, my lord, since
No, are you contradicting the order passed by this court?
No, my lord. My humble submission is that, my lord, since, my lord, all the provisions, my lord, carry maximum penalty up to 3 years, my lord. And also, my lord, no notice under section 41A was given to the present petitioner, my lord. So if he is given an opportunity, my lord, to appear for the IO, my lord, he will appear and cooperate with the investigation, my lord. Thereafter, my lord, if your lordship thinks, my lord, that his custodial inquiry detention is required, my lord, or interrogation is required, my lord, then lordship may take a call, my lord. But at this stage, my lord, since all the other named accused persons, my lord, were already released on bail, my lord, were named in the FIR, my lord. So perhaps, my lord, at this stage, his custodial interrogation may not be required.
Yes, so whether the other accused persons have been granted bail?
Yes, yes.
Mr. Locker?
From that, I have not gone through notificate expect lordship. That I will see lordship.
And whether any materials are available against this person?
Sufficient material lordships. He runs a sawmill.
Okay, you go through the case diary and let this court know about the materials after some time.
42.
Lordship, this is the 438 application, your lordship. Would file the FIR from 812, your lordship. This is related to the theft of cow, your lordship. Your lordship, what happened, your lordship? The petitioner number 1 is the owner of a Baleno car, your lordship. His driver took away the car, your lordship. The petitioner happens to be from Tejpur, your lordship. And the driver is from Dorong district, your lordship. He took away the car, your lordship. Suddenly he came to know that the car has been, along with stolen cow, has been apprehended in Dorong district, your lordship. And your lordship, thereafter, your lordship, he is apprehending arrest, your lordship. It's a brand new Baleno car, your lordship. And your lordship, apparently, your lordship, no one will use a new Baleno car of himself for theft of cow, your lordship. His honor, your lordship, his name is there in the FIR, your lordship, as the owner of the car. Your lordship, they have come to know, your lordship, it is very easily available to know, your lordship, who is the owner of the car, your lordship. So he has been implicated, your lordship. And your lordship, the car and the stolen property, alleged stolen cow is in the custody of the police, your lordship. So my humble submission, your lordship, maybe custodial interrogation is not required. And your lordship, and the owner is nowhere, your lordship, related with this, your lordship, case, your lordship. They are from Tejpur, your lordship.
So there is specific allegation against you. Yes, any other material in the case diary?
That is lordship, because lordship, that vehicle has been, police has interested with the vehicle lordship, because lordship, on the day itself, lordship, when it was, the 2 cows were inside the vehicle lordship. And nowadays, lordship, it is completely, the concept is changed, lordship. All the times lordship has already found, lordship, that and all vehicles are small vehicles are used in transporting the cows, lordship. Nowadays, Baleno, XCB, all a big car, lordship. I don't know how it is used,
It's a
lordship.
small
But
car, your
lordship,
lordship.
it is
Your lordship,
not.
I am the owner, your lordship.
So
The
many-
driver took away the car, your lordship. I was not
It
at
is
all
the-
aware, your lordship, what happened with the, just because the car is registered in my name, your
It is a
lordship.
normal P. When
Your
driver
lordship,
will say, driver,
cannot be a reason.
another way, next day driver will come. Driver will say, the driver owner asked me to bring that cow. I do not have any knowledge. And when the owner will come, driver has done it on his capacity.
No, there's a Sahanur Ali. There's a second
Second petitioner is my cousin.
second applicant.
Second applicant is my cousin, your lordship. He is nowhere connected. His name got name got implicated because when they came to know that the car is being apprehended, he tried to inquire about the car, your lordship. And they
Okay,
I don't know, lordship, why he has a file of
let me see the case diary.
lordship.
Heard Mr.
I Hussein, your lordship.
Learned counsel for the applicants, and also heard Mr. E.S. Locker, learned additional PP for the state respondent. Apprehending, arresting connection with Dolgaon PS case number 411, 2023 under section 379 IPC. This application under section 438 CPC is preferred by 2 applicants, namely Abdul Matlib alias Matlib Ali and Saharul Hassan alias Mohammad Saharul for grant of pre-arrest bail. The above noted case has been registered on the basis of an FIR lodged by one Abdur Rahman of Doipam Police Outpost under Dolgaon PS on 25/12/2023. The essence of allegation made in the FIR dated 25/12/23 is that on 24/12/2023, while he along with police staff were attending patrolling duty, then at Duliapara Gaon at about 2:30 a.m. they have found one Baleno car without number plate and two motorcycles along with 4-5 persons waiting in front of the house of Mohammad Manohar Ali. And seeing the police party, they have fled away. Then, having searched the Baleno car, they have found two numbers of cow inside the car. And one Manohar Ali, one Rafiq Ali, trim bucket driver, Mohammad Motleb Ali, vehicle owner, and Mohammad Sahanur Ali are involved in the scene. The learned counsel for the applicant submits that the applicant number 1, Motleb Ali, is the owner of the vehicle, and without his knowledge, the driver Rafiq Ali has taken the vehicle and loaded the cattle, and that he is no way involved with the offense alleged in the FIR, and that Sahanur Ali is his cousin.
So yes, your lordship, he's his brother, cousin, your lordship.
He is cousin brother of the applicant number 1, and he is also no way involved in the offense alleged, and therefore it is contended to allow the petition. Whereas Mr. T.S. Locker, learned additional PP, has produced the case before this court and submits that the IU has collected sufficient materials in support of the allegation made in the FIR, and therefore Mr. Locker has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Locker, learned additional PP. In view of the materials collected so far in the case diary and also in view of the nature and gravity of the offense as well as the submission of learned advocates of both sides, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. This 50,000 and CJM Durham Malder.
56.
Your Lordship, I will appear before the Ayur.
Definitely.
Lordship. Within 10 days, Your Lordship.
Yes, legal lordship. This is a matter for relating to Saint Mary's lordship. And the Sashigate case lordship. And in fact, lordship, it is not a case of Saint Mary. And the day of Mary's lordship, she was engineered 4 days. Lordship, FIR is at page 7, your lordship, page 9. FIR is lost by some. other-
Whether notice was served upon the respondent.
One of the victims cited here, lordship.
Pardon?
I'm appearing for respondent number 3, my lord.
Respondent number?
3,
Victim.
the victim.
Acha.
And she is measured on the day of Mary's lordship.
The case diary has been received, Mr. Sharma.
Sarcited case, scan copy of
Sarcited case.
Madam. Scan copy of LCR was called for that had been received. That is shown in the resolution. My lord, page 9 is the FIR lordship. But there is no allegation of falsehood, and this FIR is lodged by some other person. These are common lordship allegation. The lordship may kindly come to page 18. This is the admit card.
So, search sheet has been submitted against the applicant
Yes,
under
yes.
section
My lord, under section
6.
6 against the present petitioner. My lord, you are also- you are
Admit card is at page number
18, lordship. Date of birth, your lordship will find 2/3/2004. And
So, when the FIR was filed
yes, lordship, FIR was filed, lordship, that is on
on
2/2/2023.
2/2/2000.
23, and marriage took place on lordship 6/3/2022. Marriage took place 6/3/2022.
So, 6.
6/3/2022.
Whether the victim girl was a major on that day.
Yes,
Yes,
18 years, 4 days. We are also going to challenge that.
So, you have any objection in granting? No objection. Yes, so who is appearing for state?
Marriage certificate is page 20, lordship. 20. We are also going to challenge that charge sheet and charge sheet also by way of filing criminal petition. We have not filed, but we are going to file because it is not a case of child marriage and pasture.
Yeah, heard Mr. M. Khan, learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent number 1 and Madam
K Burman.
A.
K Burman.
Barman. Learned counsel for the respondent number 2
3.
and 3.
3.
3. Respondent number 2 is the police officer.
Informant, yes.
Informant. So, Mr. Bhuya, you were no, Mr. Sharma, you were representing him. This application under section 438 services preferred by applicant Saddam Ali Sheikh, who has been apprehending arrest in connection with special P case number 52 of 52 within bracket BZ and 2023 arising out of Bangladesh PS case number 70 of 2023 under section 17 of POCSO Act. Read with section 9/10 of the Prohibition of Child Marriage Act. This to be noted here that above noted case has been registered on the basis of one FIR lodged by one. Who is the complainant of this case?
Ramakanto Burwal.
On the basis of one FIR lodged by UBC Ramakanto Borua of Boeing of yes.
Vidyapur Outpost.
Pardon?
Vidyapur Outpost.
Vidyapur.
My lord.
Of Vidyapur outpost under Boeing of yes.
My lord.
The essence of allegation made in the FIR dated so and so is that one guard, namely Srimati X, name withheld of Barsala Place, was forcefully married to a man married to one Saddam Ali of Barsara Village. And that at the relevant point of time, the girl has not attained the majority. Mr. Khan, learned counsel for the applicant, referring to Annexure 3, the admit card issued by Board of Secondary Education, submits that the marriage took place on 6/3/2022 and the date of birth of the girl is 2/3/2004 and on that day on the date of occurrence on a date of marriage he has already attained majority and that the said marriage was solemnized as per Muslim rights and the same was also registered in the office of the Muslim Marriage and Divorce Register Bilasipara on 23rd/5/2022 and that no offense under section 6 and Child Marriage Act 6 of the POCSO Act and under Child Marriage Act are made out against the applicant and therefore Mr. Khan contended to allow the petition. On the other hand, Mr. B. Sharma, learned additional PP. Yes, Mr. Sharma, what is your submission?
My lord, this my lord, no objection, my lord.
No objection.
My lord, in victim, my lord.
Yes. No, what is your submission?
Actually, my lord, I have not gone to the, my lord. NCR, my lord.
Pardon?
NCR, my lord, I have not gone to, my lord.
Go through it. It is available here. You inform us. What is your submission? You inform the court. On the other hand, Ms. So-and-so learned counsel for the respondent number 3, the victim submits that she has no objection in the event of allowing this anticipatory bail application and that the date of birth as mentioned in Annexure 3 is the correct date of birth of the victim girl. Having heard the submission of learned advocates of both the parties, I have gone to the petition and the documents placed in the record. And it appears from the Annexure 3, the admit card issued by the Board of Secondary Education that the date of birth of the victim girl is 2/3/2004. And it also appears that the marriage was solemnized on 6/3/2022. And on that day, the victim girl has attained the majority. Yes, Mr. Sharma, you go through the statement of 164. After some time, we'll complete the dictation.
57.
Pardon? Yes. What is your submission?
Call for record.
Call for record. Yes, Mr. B. Sharma, on the other day, you have submitted that search sheet has been submitted here in this case.
My lord, my lord.
So, under which section and against
Fine,
whom search sheet was submitted?
After some time, after I will say that. Here is also say that search sheet submitted, my lord. But after some time, my lord.
Okay.
Order number 43 made us for orders.
Yes, Mr. Lordship. Lordship, kindly see the order passed by the Honorable Plasma Court. So, my lord, this is for service of notice, my lord, report, my lord. So, as per that order, my lord, service is, my lord, complete, my lord. The I is for condemnation of delay. My lord, is filing the related criminal revision petition, my lord. So, my lord, service is complete, my lord. So, Lordship may consider the condemnation petition, my lord. Lord, there is some delay in filing the condemnation petition, my lord.
Many no petition. Many no petition. Many delay. Delay many.
Delay 360 days. 360 days.
Yes, Mr. Loskar.
Service is completed. If service is completed and other side is not appearing, we have no objection with online.
Heard, Mr.
Yes,
Learned counsel for the applicant and also heard Mr. Loskar. Learned additional PP for the opposite party of like respondent number 1. Order dated 29/11/2023 indicate passed by the Lozimba Court indicates that as per track consignment report available in the case record indicates that notice in respect of respondent number 2 has been delivered to the addressee on 8/9/2023 and as such service is completed in respect of the respondent number 2. But the respondent number 2 remain unrepresented today. The learned counsel for the applicant submits that this interlocutory application is filed under section 5 of the Limitation Act for condemning a delay of 368 days in filing revision petition challenging the ex parte order dated 38/4/2022 passed by the learned Chief Judicial Magistrate South Salmara, Mankasar in Miss Case number 29 of 2020 under section 125 CRPC, by which the learned court below has granted maintenance allowance at the rate of rupees 7,000 to the respondent number 2 from the date of filing of the petition. The learned counsel for the applicant further submits that why you could not file the revision petition in time?
First of all, notice was not served, my lord, in appropriate address, my lord. But at the relevant time, my lord, the petitioner was deployed in, my lord, Naibili of Tamil Nadu, my lord, being a CISF constable, my lord. So notice was not served, my lord, in that address, my lord. So that is
The learned counsel for the applicant submits that the impugn order is an ex parte order without causing service of notice upon the respondent number 2. No, without causing service of notice upon the applicant, as at the relevant point of time he was serving at
Naibili of Tamil Nadu.
pardon
Naibili.
Naibili
of Tamil Nadu.
Tamil Nadu as
CISF constable.
constable. And therefore the learned counsel submits that the petition, the criminal revision petition could not file in time, and the delay is not intentional, rather it is circumstantial, and therefore it is contended to condone the same. On the other hand, Mr. Locker, learned additional PP, submits that since the respondent number 2, opposite party number 2 failed to turn up in spite of service of notice, he has no objection in the event of condoning the delay of 368 days in filing the criminal revision petition. Having heard the submission of learned advocates of both sides, I have gone through the application and the documents placed on record. And it appears that the impugn order dated 38/4/2022 was passed by the learned Chief Judicial Magistrate South Salmara ex parte. In view of the explanation so forthcoming for the delay of 368 days, this court is inclined to accept the same and to condone the delay of 368 days in filing the connected criminal revision petition. In view of the order passed by this court in criminal 697/2023, now the registrar shall proceed to register the criminal appeal and to place the list the same before the court.
Criminal revision petition. Apply.
Item 44. The eyes for suspension of sentence. The opposite, the information has appeared and full objection. Also the answer has been received, and we also the file paper version.
Informant has appeared.
Appeared and file objection.
File objection.
Yes, sir.
Whether the LCR has been received.
Yes, sir.
Paperwork prepared.
Sure, I filed a paper at a time of filing the case. It is there in the record.
What is the period of sentence?
8 years.
8 years.
Under section 304B, Because it is SIL and not dowry debt. In FI was raised on a second.
Natural death or dowry death?
In SIL debt.
Natural death.
There is an injury of the spleen.
Acha, okay, if the paper book is ready, we can finally hear the matter. Why this piecemeal way?
On 23rd January.
Of this month,
Of this.
Kabir?
Last part of this month, Lordship. Many cases.
On
30.
On 30.
30.
Maybe on 30 or on 1st. On 30th.
30th. Okay. Heard Mr. Gogoi, learned counsel for the applicant, and also heard Mr. P.S. Locker, learned additional CP for the respondent number. Respondent number 1 and madam, learned counsel for the respondent number 2. It is submitted at the bar that the LCR has already been received and paper book has also been prepared and filed. And as such, the matter is ready for final hearing. In view of above, it is provided that Restek shall list the matter on 30th, 31.
30.
Yes, 30th 1/20/24, along with the criminal appeal, and on that day, endeavor will be made to hear and finally dispose of the matter, entire matter.
Timing 56.
56.
Yes, my lord. Our date of birth is, my lord, 15/1/2003, and my lord, date of marriage, my lord, 60/2/22. At the time, my lord, he
Cross 18 years.
Yes, man. More than 18, man.
More than 18.
More than 18.
Mr. B. Sharma, learned additional PP also fairly submits, having gone through the record, fairly submits that on the date of marriage, the victim girl was more than 18 years old. Last কি করলো?
It appears that Annex 3 in the
After having heard the submission,
having had the submission of learned advocate for both sides.
no, the Pishore.
It appears from Annex 3 in the admit card issued by the Board of Secretary. It reflects that the age of the victim girl is 2/3/2004, and it also appears that the marriage was solemnized on 6/3/2022. And on that the victim girl has attained majority.
In view of above, and also in view of the submission of learned advocates of both sides, this court is of the view that a prima facie case for granting relief under section 438 CRPC appears to be made out here in this case, and accordingly this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with so and so, he shall be released on interim PRS bail till
31/24.
On that day, the applicant shall appear before the learned court below and apply for regular bail. And in the event of filing such an application, the learned court below shall consider the same in accordance with law. In terms of above, this AB is disposed of.
45.
Order passed in bail application.
At page 8, you will find the order. Standing counsel ethical, it should be shown as NCB, not DRI. And in paragraph 8, Lordship, Mary Lordship, it is noticed that the conduct of some co-accused persons, on the other hand, are not satisfactory that they have defaulted in appearance to participate in a trial of the case despite coercive actions were being initiated against them, and sometimes, as noted by the learned trial court, for want of due diligence of the prosecution DRI.
At NCB.
NCB court. And in paragraph 9, it may be mentioned that the intelligence officer of DRI, again, it should be NCB.
So this is only correction. Any other?
And page at paragraph 12, Lordship.
Yes, you have already pointed out that.
Lordship.
So in 3 paragraphs, they said DRI has to be read as NCB.
Yes.
Okay, heard me, sir.
D. Burwala.
Learned counsel for the applicant. And also heard Mr. B. Sharma, learned additional PP for the state respondent. This interlocutory application is preferred by applicant. Pranab Das.
The case of NCB Melo.
Acha. No one is present.
No one is present.
When Lady appeared. Ah, a junior ever guys. কি নাম এস কাকলিয়া এবার মাতি দিলে ভাল নেকি এবার জনাই দিব for modification stroke correction of the order dated 19/10/2023
17 that also.
17 yes 17/10/2023 passed in BA number 2905 of 2023. Mr. Borwa submits that while passing the order dated 17/10/2023, inadvertently, in paragraph number 8, 9, and 10.
Plus even in third paragraph also, at page 8. Art ethical learned standing counsel DRI.
In paragraph number 1, paragraph number 8, paragraph number 9, and 10, this court has recorded the name of Mr. S.C. Kayal, standing counsel as DRI, but it should have been NCB instead of DRI, and therefore it is contended to make necessary correction of the same. Further, having heard learned counsel about the parties, I have gone to the petition and the documents placed on record, and it appears from the order dated 17/10/2023 that in the paragraph number 1, 8, 9, and 10.
Not 10, Lordship, 12. Last
12. Yes, 12. The designation of Mr. S.C. Kayal learned is mentioned as learned standing counsel DRI, and in fact the same ought to have been NCB, and accordingly it is provided that in the order dated 17/10/2023, in paragraph number 1, paragraph number 8, 9, and 12, instead of DRI, it should be read as NCD for all purposes in terms of this IAS disposal.
46.
This is under section 482 CRPC application filed by 2 petitioners. Petition number 1 is Lot Mandal and petition number 2 is Dr. Miller. I have taken steps upon the respondent number 2.
Respondent number 2.
Yes, appeared, my lord, which is now pending for stay of this proceeding in GR case number 601 of 2022, pending in the additional court, additional CGM Nalbari. Also regarding the charge sheet is at page 26. It was registered under
Oh, the
section.
case is pending for today. It is pending for
The application that the prayer has not yet been granted.
Service is completed, then Lordship may kindly fix it for admission hearing, Lordship, then
admission hearing.
Lordship. Service completed, Lordship.
Okay, heard Mr. R. Goswami, learned counsel for the petitioner, and Mr.
C.S. Sarkar.
learned counsel for the respondent number 2.
Two.
And Mr. P.S. Lokor, learned additional PP for the state respondent number 1. It is submitted at the bar that service has already been completed here in this petition, and the matter is ready for admission hearing. Accordingly, it is provided that registrar shall list the matter on when
Lordship may allow to file a affidavit in this case.
yes,
6 February, my lord.
6 February. In the meantime, the learned counsel for the respondent number 2 may file objection if so advised.
Much obliged.
Item number 58 for hearing.
40
Huh? 58 for hearing matter upgraded.
May resolve also.
My lord, this appeal, my lord, has been preferred, my lord, against the judgment and order dated 3/6/23, passed by the learned session judge Dhubri, my lord, in sessions case number 52/2021, convicting the appellant under section 14A(b) of the Foreigners Act 1946 and, my lord, 489C of the Indian Penal Code,
Yes.
hereby sentencing the appellant for a period of 3 years, my lord.
Yes.
Yes. If your lordship will kindly see the FIR, my lord.
So the interim judgment is at page number 15.
Yes. Page number 12, my lord. It starts from page number 12. Kalam Ali, my lord.
Yes.
The name of the appellant is Kalam Ali.
12 is the that is the order. Judgment is at page number 16.
Yes. 50.
So he has been found guilty under section.
My lord, 14A(b) of the Foreigners Act, my lord, and 489C of the Indian Penal Code. If your lordship will kindly see the FIR, my lord. The allegation against him.
So total of 5 years he has been sentenced. 2 years under this 489C
Yes.
IPC and 3 years
Yes.
under section 14.
Yes.
14A.
Accordingly, I sentence the accused convict Kalam Ali to suffer rigorous imprisonment for 3 years and to pay a fine of rupees 10,000 only in default to suffer imprisonment for another 6 months under section 14 AB of the Foreigners Act 1946, and also sentence him to suffer rigorous imprisonment for 2 years and to pay a fine of rupees 5,000. Only in default to suffer imprisonment, simple imprisonment for another 3 months under section 489C of the Indian Penal Code. The terms of both the sentences shall run concurrently.
Yes.
Your Lordship may kindly see the FIR first.
At page number?
The lower court record will be.
Bobby, where is the record?
Been taken by AP.
Acha. Yes.
My lord, as per the FIR, my lord, the allegation against the appellant was that, my lord, on 26 June 2021, at around 9 PM, my lord, the personnel from the BSF 67 Battalion, my lord, they laid an ambush, my lord, and apprehended the appellant Kalam Ali and recovered 49,500 fake Indian currency notes, my lord. And this FIR, my lord, was registered under section 120B, 489A, 489B, 489C, the Indian Penal Code, read with section 610 of the ED Act, and also section 14 of the Foreigners Act, my lord. On the same day itself, my lord, the appellant was apprehended. And, my lord, the police, after investigation, my lord, submitted charge sheet under similar sections, my lord. Thereafter, my lord, the court also took cognizance under similar sections as were registered in the FIR, my lord. Now, my lord, after the trial started, my lord, the prosecution examined 7 PWs. And after hearing both sides, my lord, the learned court below convicted the appellant under section 14AB of the Foreigners Act and 489C of the Indian Penal Code, and also acquitted the appellant from the offences under section 489A of the Indian Penal Code, 489B, section 12(1)(c) of the Passport Act. So, my lord, that only 2 points for consideration will be whether the appellant has really committed the offence under section 14AB of the Foreigners Act and section 489C of the Indian Penal Code, my lord. So, in this regard, my lord may kindly see 14AB of the Foreigners Act.
No, first they come to the IPC offense.
I-
14
My lord, it relates to the possession of fake Indian currency notes from the possession of the appellant, my lord. However, my lord, this will be more relevant, my lord.
Which one?
14, my lord, Foreigners Act.
No, you first come to
Right.
this point.
My lord will see the discussions of the learned court below at para number 19. It starts from para number 19 at page number 29 of the judgment. So the learned court below
So, what wrong the court below has committed?
yes, had relied on the evidence of PW1, PW5 and PW7 in coming to the finding that the appellant was in possession of
fake
Hmm.
Indian currency notes, my lord.
Hmm.
Now, in this regard, my lord, there are two seizure lists, my lord. The first seizure was made by BSF, my lord.
Hmm.
If your lordship will kindly see the initial seizure, which was made by the BSF.
Hmm. It is the exhibit 6.
Yes.
So it bears your signature also, your thumb impression,
Yes. Yes.
and two other witnesses.
Yes. In the seizure list, my lord, there are two witnesses, my lord, Dilip Kumar and Siddharth Singh, my lord.
Hmm.
So, my lord, Dilip Kumar was examined as PW5
Hmm.
and Siddharth Singh was examined as PW6.
Hmm.
So, if your lordship will kindly see the evidence of PW5. Dilip Kumar.
Hmm.
He says that, my lord, I do not know the accused present in the court today. So,
Hmm.
he straight away denies to identify the accused person, my lord. Thereafter, he says that I am the complainant of this case. On 26/6/2021, I was posted at Panbari BSF camp, Dhubri as constable. On that day, I was on duty at Tistarpar BOP. Though I have lodged the Ezahar in connection with this case, but I have no knowledge about the facts of the case. Thereafter, my lord, the learned CP moved a prayer for declaring the witness as hostile, my lord.
Hmm.
And after that prayer was allowed, my lord,
Hmm.
the prosecution side, my lord,
Hmm.
attempted to contradict the witness, my lord, by drawing his attention to the previously recorded statements under 161.
Hmm.
Now, if your lordship will see, once, my lord, the PW5 was examined, my lord,
Hmm.
thereafter, my lord, the prosecution ought to have proved that contradiction by examining the IO, which
Hmm.
was not done in this case, madam. So, lordship will see 162 of the CRPC, madam.
Hmm.
162 of the CRPC, the proviso, it says that provided
No,
that
where is
weight,
the evidence of IO?
IO is at PW4.
PW?
4. PW4 is the IO of this case.
Who submitted search it?
Yes.
Hmm. So IO has not confirmed the statement
Yes.
made before it.
Yes, my lord, 162, the proviso to 162 says that provided when any witness is called for the prosecution in such inquiry or trial, whose statement has been reduced into writing as aforesaid, any part of his statement, if duly proved. So that statement must be duly proved, my lord, and then only it can be used by the defense or with the permission of the court by the prosecution, my lord. So, my lord, normally the side which calls the witness, my lord, he initially records the examination receipt, my lord, and if he wants to cross-examine that witness, my lord, he will have to obtain permission from the court. And if that contradiction is to be done with the previously recorded statement, my lord, then 145 of the Evidence Act must be complied with. That means his attention must be drawn into the earlier recorded statement, my lord. And also, my lord, that statement, my lord, who has recorded that statement, my lord, that person will have to be called so that he proves that actually he had recorded the statement, my lord. In this case, my lord, if your lordship will see, after, my lord, the witness was challenged with his previously recorded statement, my lord. Thereafter, my lord, the prosecution ought to have re-examined the IO and ought to have proved his previously recorded statement, my lord. In this regard, my lord, I would like to place a judgment of this Honorable High Court, my lord, in Misir Ali versus State of Assam.
No, that's all right. That is settled position that
Yes.
It has to be confirmed
Yes.
by the IO
In
concern.
this case, my
But
lord,
here it has not been confirmed.
no, my
Now the question is whether the court below has relied upon the evidence
yes,
of this witness.
yes.
if your lordship will come to para number 21, the learned court below says that from the testimonies of PW1, PW5, that is this person, my lord, who was declared as hostile, it is clearly established that on the day of occurrence, that is 27/6/2021, the accused had in his possession of total 99 numbers of fake currency notes.
Hmm.
Which ought
Okay,
not to
then
have-
PW6,
Yes, PW6, my lord. My lord will kindly see the evidence of PW6.
he is not declared hostile.
No, but he, my lord, he says in his cross-examination, my lord, if your lordship will see, he says that I do not know who and where PW6, that is Caesar list, was prepared. I do not know the contents of the Caesar list. I do not know what is exhibit PW6, man, P6. I do not know about the place where I put my signature. So it cannot be said that that Caesar list was proved by the prosecution. And if that initial Caesar was not proved, then that chain of custody is not established, my lord, because Assam police receives that fake currency from BSF, my lord. So initially, my lord, the Caesar list prepared by the BSF ought to have been proved. But the initial Caesar itself has not been proved by the prosecution.
So according to you, Caesar has not been proved.
Yes. If your lordship will see the Caesar list.
The informant also declined having filed a declined having
Yes, yes.
filed and knowing the contents of
Yes,
the FIR.
yes, yes. If your lordship will see the Caesar list that was exhibited in
Oh,
exhibit
yes,
1.
okay. Then next point.
Yes. My lord will kindly see section 14 of the Foreigners Act.
How long the person is behind the bar?
2 years, 6 months.
2 years?
6 months.
Yes, section.
14A-B.
(14)
Yes. Capital A, small b.
Yes.
It says that, my lord, whoever enters into or stays in any area in India without the valid documents required for such entry or for such stay, as the case may be, under the provisions of any order made under this act or in direction given in pursuance thereof. So, in order to contravene any provision of this act, this particular provision, my lord, a person must first enter India, and then, my lord, he must have entered India without any valid documents, my lord. So our contention before the learned court below was that he never even entered India, my lord. He was detained from within Bangladeshi territory, my lord. That was our contention before the learned court below. If your lordship will kindly
How far that contention is believable?
yes, I'm coming to that, man. The appellant is admittedly a Bangladeshi national, man. He's a Bangladeshi national. So if your lordship will kindly see, para number 18 of the judgment.
Para number 18.
18.
Yes.
May I read, man? Learned advocate for the accused person argues that the place of occurrence, that is Tistarpar, is not identified properly, whether it falls within the territory of India or within the territory of Bangladesh, because no straight boundary is there. It is riverine area. There is no fencing between India and Bangladesh border. So the prosecution case is doubtful and the accused is entitled to be acquitted. So far the place of occurrence, that is Tistarpar, is concerned, PW6 categorically stated that they apprehended the accused person at Tistarpar border area. In the sketch map, exhibit 3 prepared by the IO, the place of occurrence has been shown as 1A under index column, which falls within the territory of India and the territory of Bangladesh. So, my lord, for arriving at the finding that the appellant was apprehended within Indian territory, my lord, the learned court below relied on two things, my lord. That is the first, the statement, the categorical statement of PW6, as well as the sketch map, my lord. Now, lordship will kindly see the evidence of PW6. As per the learned court below, my lord, there should have been a categorical statement that the appellant was apprehended at Tistarpar border area, my lord. But if your lordship will see the evidence of PW6, he straight away, my lord, he refuses to identify the accused person, my lord, by saying that I do not know the accused present in the court today. The very first line, my lord, I do not know the accused present in the court today. I know the complainant of this case on 26/6/2021. I was posted at Tistarpar BOP as constable on that day. I, along with other BSF personnel, were on Naka duty at Tistarpar border area. At about 11 PM, we apprehended one Bangladeshi national, my lord. He does not say that they had apprehended the accused person, my lord, who was present on that day. He says that, my lord, we apprehended one Bangladeshi national. And in the very first line, he says that I do not know the accused present in the court today. So, my lord, as per the learned court below,
No.
there was no categorical statement that this accused was apprehended at Tistarpar border area.
No, accused means the person who was attending trial
Yes.
at that point of time.
Yes.
So
He could not even
where you have disputed?
My lord will see.
Where you have disputed the evidence of this witness in
Yes.
cross-examination?
My lord, particularly, actually, this was a Caesar.
Only two. You have put three questions. One
Yes.
is I do not know. That is suggestion,
Yes.
perhaps. I do not know who and where PW6. No, where exhibit P6
Yes.
was prepared.
Yes.
I do not know the contents of the Caesar list.
Yes.
I do not know what is exhibit P6.
Yes.
I do not know about the place where I put
Yes.
my signature.
Yes.
But his evidence that he apprehended one Bangladeshi national.
But it follows from the premise that the accused person who was present on the court that day, my lord, he was not the person who was apprehended,
No,
because
that's all right. Then it was your duty to confirm him, confirm from
Yes,
him
but-
that he is not the person
Yes, because my lord,
whom they had
but-
apprehended
but
on
the
that day.
learned counsel, my lord, who was appearing on the defense, my lord, defense side, my lord, he perhaps, my lord, he felt that it was not
No,
necessary.
no,
Because-
here but now
Because he,
that plea is not admissible here.
because he could not identify the accused person, and he. Oh,
Where that question is?
my lord, my submission is that, my lord, the learned court below says that there was a categorical statement
Hmm.
that
No, this categorical statement
Who
that
is-
they have apprehended one Bangladeshi
yes, one
national with
Bangladesh national, my lord, but
fake
he-
Indian currency.
yes, but he could have said that we apprehended the accused person who was
Who?
present. The
No,
appellant.
that's all right. The prosecution failed to point it out, but
Yes.
what prevent you from confirming it from him that the person
Because he has
standing
already
trial is
admitted,
not
my
the
lord.
person they have
He has
apprehended?
already admitted in his chief, my lord.
Where?
Admitted, he has already admitted by saying that he does not even know who the accused person is.
Hmm.
If he was so confirmed, my lord, then he ought to have said that yes, we have apprehended or arrested the accused person who was present. But he never said so. He said that we apprehended one Bangladeshi national, man.
Hmm.
So the next my lord, material is that, my lord, the sketch map, my lord, which was
Hmm.
relied by the learned court below.
No, sketch map is hit by section 162 CFSA.
Yes,
That cannot
Yes.
be a substantive
yes,
piece of evidence.
yes.
Cannot be. Mr. Loskor, where is your case?
Kindly fix it, another receipt, make evidence further receipt. I will prepare my case.
No, what is remains to be gone through. He has already read out the material part of the witnesses examined by the prosecution side.
So I have just now read the receipt, only the judgment part receipt. I haven't gone to the LCL receipt. And receipt, it is the summary.
Hmm.
Already, my lord, he has completed 2 years, 6 months.
Any date receipt, immediately after opening receipt, reopening receipt. Any date receipt. I will go through receipt.
Yes. Fine. Heard Mr. Estes, learned counsel for the appellant. Mr. P.S. Locker, learned additional PP submits that the matter may be adjourned so as to enable him to go to the LCR. Where is accordingly allowed, register leaves the matter on
25 receipt.
25 as per third.
Highly obliged.
এটা তো করি না এগুলো একটু করিব নাকি ওকে তিনটা বের হওয়া বলি অর্ডার দিলাম
Next item.
Article 47, hearing bill.
So this is the per third matter. Yes.
They are challenging the judgment passed by the learned lordships,
Hmm.
Special Judge Bosco Amingal,
Hmm.
dated 1/7/2022.
So your contention was that no ingredients of section 8 is made out against the appellant. That is your argument.
Lordship, if your lordships will see the incident, my lord,
Hmm.
the incident complained of is touching of the breast. This is the incident, my lord. And this is the and as per this incident, my lord,
Hmm.
I have been convicted, my lord.
Hmm.
Now lordships will see this incident, my lord, that is touching of the breast has not been proved beyond reasonable doubt. There is a inconsistency in the statement of the victim.
Victim was examined as PW.
One minute.
SPW
One. PW1.
PW1.
PW. Lordships will read the statement of the victim once. my lord.
Hmm. Yes.
164 statement, lordships has got it, madam.
Yes.
On 9/7/2019, I was alone at my house. My father is posted at Arunachal Pradesh and my mother was not at home since she was at my neighbor's place. At around 11 a.m., one person came to our house for selling some articles, stating himself to be a salesperson from Big Bazaar. However, I did not open the door of our house and told him to go away. After about 10 minutes, a second person stating himself to be a salesperson from Big Bazaar came to our house and told me that we had won some gifts on some offer made at Big Bazaar. Hearing the same, the opened the door of my house, after which that person began showing me certain utensils which he told that we had won as gifts. While I was looking at those articles, that person suddenly touched my chest. Now this is relevant, my lord.
Mm.
This is the incriminating statement, my lord.
Mm.
When I was